I've just recovered. I recovered from COVID in November. But it's despite COVID, I don't think activity in the tech policy space has slowed down. I mean, just in the last week, we've been discussing free speech issues and banning of Trump and what that means for the rest of the world and world leaders and their speech. But this discussion is about the non-personal data framework, and we have a great bunch of panelists, and among them we have two committee members joining us. We on this panel, in the first panel, we've got Parminder, uh, uh, who has largely been, I would say, the soul of this entire framework. It's been a passion project for him. I remember, I think almost 3 or 4 years ago, outside NIPFP, Parminder and I were debating some of this. So congratulations on bringing it this far, Parminder. Um, and now, as all of you are aware, the NPD committee has revised its report, and they've sought views from citizens, from stakeholders, on what the final report should be like. And it's very clear that they're listening to feedback because of the significant number of changes that have taken place and limitations that have been put on the framework compared to the previous version. Um, so, there are changes with respect to sovereign access to data. The B2B data sharing is now outside the purview of this particular framework. But there are still lots of parts that remain. So we hope that today, in this truncated discussion, because last time we discussed the subject over 2 days, we hope that we will be able to crunch it a little bit and try and get you as much perspective and insight and inputs and as many questions get answered as possible to help you do your filing. Remember that our main objective is to help you get enough perspective to do a better filing and assist in the democratic process of policy making. We've had over 250 registrations for this discussion, and we typically have a 50% turnout. So I hope we get there. This discussion is being live streamed on YouTube, on Twitter, and Facebook. So should you wish to share the streaming link with anyone, we'll just give it to you on chat. We'd like to thank Microsoft and Facebook for the support for this discussion. We've divided this discussion into three different parts. The first one we're going to focus on is essentially the base premise for this discussion, the role of communities, the role of high-value data bases, data trustees, and also, importantly, sovereign access to data, as well as community access to data. The second discussion is going to be more around business aspects and what the interface of businesses with the framework will be like. The third part will focus on one of my favorite subjects, which is regulatory authorities and their scope and their function. And we'll discuss what the role of the non-personal data authority is going to be. We expect that this discussion will go on till sometime between 5:30 and 6 in the evening, because we're trying to discuss a lot in this particular discussion. So please bear with us and stay on, so there'll be perspective as we go along on different aspects and in each session. As always, we want a participative discussion. So a large part of each session will be devoted to answering questions that you might have. So please use the Q&A module in Zoom to ask your questions. And in case you wish to interject or make a point, just use the chat function to just let us know, or just ask questions and we might pull you in. When you're not speaking, and this is for the speaker, I request you to please put yourself on mute just to prevent any background noise. Virtual discussions are sometimes a bit complicated, but we try and make it as predictable as possible. So without further ado, let me start with the conversation and the discussion on this. Parminder, I'd like to start with you, because this is essentially your baby in a sense, right? This is something that you've been very passionate about. Can you tell us a little bit about what has changed in this draft versus the previous draft, and what is the motivation behind the changes?
Thanks, Nikhil, for inviting me, and good afternoon to everyone. The motivation behind the changes is basically is after listening to the comments, uh, which came in after our earlier draft, and as we were discussing just before this went live, is to we found that in some areas there's a lack of clarity, not only about understanding but also clarity about how things would be, and we have tried to reduce those clarities. And if I speak about 4 or 5 areas where the change has really taken place, you would understand what I'm saying. And I think I can describe 4 or 5 areas where the change has taken place. First is, and the most important one, is that earlier draft spoke of business to business sharing, where A business could directly ask B business uh, for certain kinds of data. And what kinds of data could be asked was defined as a category, which was called community data, which is data sourced from outside rather than inside an organization. But this was found to be a little too confusing and difficult to operationalize, that every business can ask any other business, and data is not like a package you can just hand over to the next person, even if you're ready to. It's a complex process, and that was a little messy. So now, as you would have perhaps read in the new draft, there is no direct business to business sharing. Data has to be shared through a new system called high value data sets. And I think the best way to understand them is infrastructural thinking. Some data sets are considered of an infrastructural nature. And that consideration has to come with the assent of the new non-personal data authority. And once you recognize, say, certain kinds of data, and what kinds of data is now very circumscribed. You can't just say, give me all transportation data. Certain formats will be asked for, certain depths of data, it will be very circumscribed, which can be asked for. And that creates high value data sets. And these high value data sets will be held by community trustees who are large and capable enough techno organizationally to do that. And once they hold these kind of data infrastructures, a business can ask from this high value data trustee whatever they already have, and they cannot directly ask the business. So the kind of data which now needs to be shared is very circumscribed. And this is the first thing. Second thing is, of course, there was a lot of difficulty about what is the community and how will it act. And now a clarity has been added that there are two aspects. If there's a harm to the community, any nonprofit associated with the community can ask for it. But as far as benefit sharing is concerned, there is a different process. So the community actor has been clarified. Third thing is that this report has now tried to get out of what they tried earlier to define all kinds of non-personal data, data with the government, data with private people, because definitions started to create some inclination of new kinds of private public rights, which was very confusing. And therefore we stayed out of definitions. So we have not tried now, we means the committee has not tried to define different, all the universe of non-personal data. And they've stuck to a certain kind of data sharing, which was the focus of this thing. Fourth thing, and is very important, is that they have very explicitly stated that data mandating of data sharing is not under eminent domain. And here I go back to Nikhil's paper, which was very much quoted in many places, about nationalization of data, that it's not a government under its own authority that it calls for data, but it's under a community rights frameworks, and the explicit connection has been made to different kind of community resource management, like forest, flora and fauna under biodiversity treaty, which is an international treaty, traditional knowledge. So it is a community resource. And anybody who holds that resource would be a trustee, even if a government body is involved. An explicit community rights framework has been put. And the last thing is a smaller thing, but a lot of people were very worried about a lot of back-end processing which takes place in India. And back-end processors may receive a request for data sharing, and what happens, because that will really disbalance our India's back-end BPO industry. So it's been clarified that data processors do not have this obligation. Only the first instance data collector has an obligation. So these are 4 or 5 major areas where change has taken place, and I can come back for any other clarification.
I'm just wondering, Parminder, can you just, for me, the community actors bit, could you explain who can ask for data and build those high value data sets? Like, is it clearly defined what a community is?
A community is defined, but there is, of course, never such a concrete boundary of a community as of an individual. Individual right holder is very clear, and it is recognized in all community resource frameworks that a community, whether it's around a water body or around flora and fauna, is never completely defined. Now, uh, as I said, harm prevention is something any non-profit, for example, a Delhi non-profit can get up and say that Delhi commuters' rights are being affected. So harm prevention is one side, which is an easier action to take. As far as positive rights of taking benefits, who can set up this high-value data set is a set of actors who have a stake in that high-value data set and gets involvement of enough community actors into making that data high-value data set trusteeship, and gets an acceptance from the non-personal data authority that this looks like an valid high-value data trust. So these are the general areas, and rest would be case to case.
So have you, in that context, defined what are the parameters as per which the non-personal data authority will decide the legitimacy of such requests?
No, the precise points are not defined, but the framework and the connection with existing community resource data frameworks give enough indications on what would be the basis of making those determinations. The basis is that, is there a nexus enough between, first of all, what is being called as the community and the concerned data? And second, is there a nexus enough between that set of actors who are claiming to be the representative and trustees of the community and the community? So this nexus is what is required. Whether the nexus exists, whether the closeness of these actors to one another does exist, would be determined.
Okay. So just one about the sovereign purpose bit, right? There is a concern that about government access to data under a sovereign purpose. Who determines whether a sovereign purpose is valid or not?
Okay, in this committee, in this report, as you would have read, you may say conveniently or not conveniently, the committee has said that we are not talking about that part of the data. Now, two things can be read about it. One is it is wrong. And of course, I am very much, I have always felt that non-personal data is very powerful data. It is powerful in hands of corporations, and it is powerful in hands of state. People don't talk about it, but I think the intelligence which non-personal data gives, the patterns which non-personal data gives, is also very powerful. And therefore, there needs to be a check and balance with vis-a-vis what can be shared with the government or what government can ask. Now, what the committee has done, and I just want to test that it's not only sovereign data, there's another kind of data, which is business users of platforms have data on platform, like Uber or Amazon traders have data, their data on Amazon platform, or restaurants have their data on food delivery platforms. This is a very important class of non-personal data, which this committee does not deal with, but a recent Digital Markets Act of EU says that a restaurant will have access not only to its own data, which is with the platform, but also aggregate non-personal data. So I'm just trying to give you another example of non-personal data, which this committee did not deal with. In the same way, rather than saying that this committee says that government can go ahead and deal with take away any sovereign for sovereign purpose, take away any non-personal data, it's rather stayed away from that particular thing. And I think it's very important that there is, like with personal data also, a special act which determines government's rights for it. So this is how
it's not stayed away, right? It's explicitly said that the NPDA will not adjudicate on those requests.
In the
that
sense,
means
yeah,
that means that it's rather said that it's not going to participate in the process, and the government can take it anyway. Yeah, so it's effectively tried to distance itself from that decision making and left the door open for sovereign to access data without question.
I can accept this interpretation, and I understand people will make it. Though the problem is that if the committee were to say that it will educate on the sovereign purpose, then it has to enter into same kind of principles development on what is would be. So you can't just set up an authority and say this authority will deal with what is happening. You will have to give principles on what it will deal with, how it will deal with, and so on. Like the question you asked me earlier about corporations sharing data. So you have to get into that whole area and then develop certain bases for the NPD authority to decide. And since it did not enter into that, it simply had to say that this NPD authority would not on its own be making those decisions, because this committee gives no basis or principles or guidelines to do that.
Okay, and but you do believe that, or do you believe that this still needs to be looked into before a law is formulated?
My personal opinion is that this is a very important area, but I think the law on data sharing for domestic industry and the high value data sets for what I call it a digital industrialization purpose, which is the main purpose of this committee, should be treated in a separate way than sovereign purposes, but both requires laws, in my personal opinion, separately.
Okay. Malvika, what do you think about the digital industrialization purpose that this report is seeking to further? Any thoughts on that?
Thanks for the question, Nikhil. I'm glad to be here again. I think what's interesting, to your point on purpose, is that as an outsider to the committee process, I found it hard to really ascertain what the core objective of all of this is, right? So the conceptual underpinnings of this entire regulation making process. And so it's nice to know that maybe digital industrialization is the core objective, driving the setting up of this vast non-personal data architecture. From my perspective, I basically saw 3 or 4 anxieties on driving the report. And the first one was exactly this, that there's this anxiety around NPD's economic value, non-personal data not being realized by the Indian state and Indian firms. There was another set around communities needing to benefit from the data. And then there's this bit about innovation and privacy. Now, the reason why I think the other 3 I don't know if I can call them objectives because they're not called out as objectives, but they just kind of landscape, is I think the privacy aspects, really, there is an overlap with the PDP bill there. And maybe we won't go into it right now because I'm sure the next panels will deal with that. The innovation one and the community empowerment one, I think are also a little bit vaguely framed. But with the anxiety about NPD's economic value not being extracted by India for this kind of digital industrialization, I think to squarely address that, what I would have maybe like to see is a consideration of what's currently wrong in that respect and what are the options to deal with what's wrong. Again, I would like to understand, like, what is wrong with the private markets for data sharing that do exist? And if we believe that there is a problem, and that might be, then what are the ways that people can tackle that data sharing problem? That is, I guess the assertion is that there is some kind of data hoarding, or certain firms don't get access to certain other firms' data, which is probably the premise. I mean, then what do you do as the state? Is do you try and create that private market and regulate it? Do you try and create an enabling framework for that to happen? Or do you actually set up this kind of, I would say, fairly heavy-handed regulatory architecture, right? Because you're essentially creating some kind of a public law for data after this. You're taking it, you're going from a private market into a public law for data. And on that front, I've been trying to understand, like, what are the implications of this? And maybe there are 2 things that I'd like to just put before the audience. And also, Parminder, great to kind of be in this conversation with you. I think one aspect of that is to do with rights. And the second aspect is really to do with what happens when you take this kind of subordinating approach, right? What I mean by subordinating approach is very, very classic kind of theory around when does a state come in and say who does what? And I went back to this 1939 article by Roscoe Pound, right? And that's kind of where it all, and basically there's this idea that public law is subordinating because somebody comes in and says certain rights are at clash, and I am going to tell you whose rights get subordinated and make good to them. And private law is called coordinating kind of laws, right? As in, you create a framework for contracting between people, and then they contract The state is not taking a call. It's a coordinating kind of exercise. And the issue is, as we've moved from this kind of social individualism to social institutionalism, and definitely maybe we do feel, for instance, that if the state is not there, then people are being taken for a ride. Consumers are being taken for a ride, labor is being taken for a ride. I think that's, so it's not to say that never should the state step in. I'm definitely not kind of neoliberal type. But I think the real concern there, as someone who cares about individual rights, and it's interesting that that concern is as alive today as it was in 1939, is that he actually says is that the one thing that has been constant in this shift is the autocratic power of public officials and the increase in administrative rulemaking that is substantially less accountable than legislative rulemaking or judicial rulemaking. I mean, that's just a general theory. So I think that's why the regulatory aspects of this become important, because if you're moving from a private market into creating like a public data sharing framework where the state sets the rules, then there really needs to be some fairly critical thought around what is that doing when the state steps in and picks certain people who will to make good and certain people not. There's a huge values debate there that I will not go into. The second part of what I was saying on rights, again, here I feel there's a bit of conceptual, for me at least, I felt a little bit of conceptual clarity I would have liked, because I saw 2 or 3 rights, right, dotted through the report. One is right up front where it says India has rights over the data of India. Interesting, because I was trying to understand whether this is a state granting a right to itself. So, I mean, India has a right over data in India is not something that I have seen before. So that is something new that we are doing. And then there are 2 other rights, which I presume are granted, which are mentioned as in a sort of right broadly to take benefits, and a right to minimize harm. And I guess what is interesting is this right granted to the community or to the individual or to whom? To India, and I think, and the reason why this, again, I think is an important conceptual issue to get right before you get into a lawmaking stage, is that, we do have a law of data governance in this country after Puttaswamy. And now what Puttaswamy has done very clearly is set out a few specific things in terms of where rights in relation to data are vested, whether or not they are raw personal data, right? And this takes me into some specific points that I wanted to get into later in the conversation around metadata, anonymization, things like that.
Okay. No, but Malvika, sorry to interrupt, but do communities have rights?
This is the interesting thing, right? I mean, what I found difficult in this report on the point of, and here I'd like to just maybe pick up on a few things that Pandit already mentioned. Now, the issue is that the way that the community concept is defined in this report, and if these rights are to vest in communities, which is kind of an interesting and slightly ambiguous concept, I would say, to me, and I can get into why, is that because it says it's geography, social interest, anybody bound by any interest. And the thing we know, and that maybe we've talked about previously, is that many of these data-driven communities aren't even aware that they are a community, right? Because you do not know that your data is of high value because you all own like a particular kind of car, for instance. And that kind of community organically creating its own data trustee, registering it as a Section 8 company, and then using that to protect its data is pretty, it's a difficult thing for me personally to wrap my head around. So, I mean, I feel like while the intent is very laudable that, Indians' data or like data that we are generating shouldn't be kind of just extracted by some company who does not funnel back interests to India, whether that's to the state or Indian themselves. I think the way that we go about it here I'm not sure who benefits from this, because ultimately, if you bring it all back to that objectives discussions that we were having, I think my concern is the people who will be able to benefit from this, the current way that it is set up, is basically kind of large Indian software firms who want to access other firms' data sets. Because having spoken to smaller Indian firms, they are very worried about this as well. So then the question really becomes, in this current context, if these are the objectives, is to ensure that there's a safe, secure data sharing, then do we need to be erecting such a highly engineered framework for data sharing, like a technical framework, because it says, this person will request, this one will share, when the conceptual underpinnings still we don't have as much clarity as I would like to see. So for instance, something like the first white paper on data protection, which sets out, right, co-regulation, X-regulation, what is the scope of personal data, and so on. So I think those were 2 or 3 points. I mean, I do have other things to say, Nikhil, but I mean, I'm happy to maybe pause for the
So,
moment. And
so I have one last question before we bring in Subhashish. What do you think about sovereign rights here? In the sense, do you think that has have sovereign rights been looked at in this manner in the past, in any judgment, in any um, like it's almost seems like this is similar to the government getting a carte blanche access to personal data. Are there any concerns related to that?
yeah, I mean, I guess, yeah, a lot of, I think the concerns around any of this is coming from that background context in which we are operating, right? I mean, again, kind of 101 on rights that many of us will know, there are 4 kinds of rights. And we've talked about this again in previous MediaNama discussions, I think. And I'm not able to see that the rights here fit into any one of those 4 conceptual categories that traditionally you think of as rights for the last hundreds of years. So it's either a privilege or a claim, which is a primary right. So you're giving someone a privilege, or someone can make a claim, or it's a secondary kind of right, is a power or an immunity to trump those privileges and claims at a very, very conceptual level. Now, here, when you have a very highly defined, India has a right to Indians' data, and then the other two, which is a right to benefit and a right against harm, which are pretty loosely worded, without us knowing exactly whether that right is given to a community or to an individual. I think my fear is India has a right to Indians' data, or data in India very much flies in some sense in the face of Puttaswamy for 2 reasons, right? One is that we have located data as an extension of the self.
Yes.
And the great thing about this report is it says mixed data sets are subject to personal data protection law, right? But then it goes on to this idea of metadata, and that, it having a privacy, there's privacy that it needs to protect, certain privacy imperatives and so on. So my question is, like, what is really left over? And if India is going to have, if the state is going to have, are you bringing in a power right for the state to trump the privileges and claims that have been so hard fought and won through Puttaswamy, through all of this, saying we have a right to privacy, it's an extension of ourselves, we have a right XYZ? Because the minute you then move it up and say the state is going to, and while I completely appreciate the changes in certain respects to eminent domain, I think there are a couple references still remaining to eminent domain. And I think that's where I start getting really uncomfortable, because I think using a land rights framework, using that kind of forest rights framework for data can be actually, my concern is it can set consumers back because of this problem that so many of the data communities aren't real world communities. It's not like they're people of a particular tribe. They are just somebody in a data set somewhere who are vested with rights and expected to exercise them. And then if they don't, it's like no win, no fail, right? Like, I don't know that I'm being profiled for XYZ region, and and I might have metadata, and this is a point we're coming back to. Even non-personal data is often in a mixed data set. So I would be very keen to understand what's left over for this framework to regulate, if most of it is going to come under the PDP bill itself. It's a long question, pointed answer to your question, but I don't know if that we got there in the end.
So Parminder, we'll come back to you with these questions. I hope you're taking note for some clarification, but I'll move to Subhashish. Subhashish, in our conversation prior to this discussion, you mentioned that there are areas where this report needs to, where the committee needs to provide clarifications. So what kind of challenges are you seeing, and what kind of clarifications do you want?
Thanks for the question, Nikhil, and really glad to be here alongside 2 panelists whose views I always look up to and look forward to. So to your question, look, I think I'll build off of something what Malvika said, and I have a certain different take on it, and then go on to some of these, I think, where the biggest gaps here lie. I think, Malvika said that the very purpose of this framework is something that's unclear. And the way I interpreted it, and it's not explicitly stated as such, is that if you take a classical economic thing of when should the state step in and regulate any kind of markets, there are certain, there's information asymmetries, externalities, etc. If you look at data markets, they're very, very strong externalities, because the data that company A collects would be useful to a non-profit B or a company C or a government D. But because this company that's collecting the data will not ever be able to monetize each and every possible use case of that data, it does not have the incentive to share and create that private market in data that we spoke about. And therefore, there is a role for some sort of regulation to overcome that market failure, which is that externality. The question is this approach the best way to do it? I do not know. And I think that's the argument people who work on regulatory governance always make, that you should lay out all the possible approaches to solving that externality and then choose the best. But is this a credible and sensible approach to doing so? I do think at its fundamental level, yes. And I think the benefit...
It's kind of subversies like that, the asset utilization argument that ride sharing companies make, right? Kind of similar to that.
Somewhat. And I think to that extent, therefore, the best thing about this revised report is that it very closely narrows down what it does and what it doesn't do. So I almost don't look at it as a general non-personal data governance framework. I look at it as how do you utilize non-personal data for public good purpose. And therefore, the questions around sovereign access, etc., which I'll come to towards the later part of my comments. Now, to facilitate all that market, right? I think the intention, and Parminder should correct me, I see an intention to try to make this as self-driving as possible and not to have a very heavy-handed approach. And that's where I think some of the biggest gaps in this framework are. I just don't see that level of specificity around institutional design and incentives that one would like to see in a framework like this. So in particular, I'll bring up 3 points, right? Firstly, this whole question of the adequate state role. So while I said that, look, I think some sort of regulation is important to overcome this market failure. I feel like in this case, the government has a very overbearing role in this entire ecosystem, because the government through the NPDA, which in India, we know regulators are typically not independent regulators. So the government through the NPDA is going to determine which community gets represented as a trustee. It's also going to adjudicate through the NPDA on, there will be a lot of litigation coming out of it, that this is inferred and this is raw and all of that. And I think the NPDA will adjudicate on all of that. And given the history of regulatory governance in India, that just doesn't give me a lot of comfort. That I feel like while the intention is to create some sort of kind of marketplace and facilitative role, I think the government's overbearing role might actually end up defeating the purpose. The second thing that I would say is that this question of protection from harm and the duty of care is a recurring theme that we see for both data custodians as well as data trustees. I do not think that has necessarily been defined well enough. So firstly, the question that MediaNama, I think, put in its summary of this bill, which is, should this protection from harms be a parallel goal with the creation of value, and are they in conflict? But apart from that, some of these duty of care obligations, why should they do it in the first place, and what happens if they don't do it? Some of these things have been just left undefined. And I think the biggest problem that I see, or the biggest area for improvement, if I was to put positively to here, is that this whole public good narrative that is driving the spirit of this entire thing, I just don't see enough incentives within the framework for the different stakeholders. So clearly, the one of the two most important stakeholders is the data trustee. And we say that it must provide non-discriminatory access, but at the same time, it must also ensure that data is used for public good. So the fundamental question of, does a data trustee have discretion, and how much discretion does it have, I think has been left somewhat undefined. And similarly, I think the fact that are there any obligations of the data requester? It says the data requester must use it for public good. So is the data requester not allowed to use it for commercial gain? Is the data requester, if they don't use it for public good, is there some accountability mechanism that they will have to meet, etc.? So I think some of these gaps in the framework give me a little bit of concern, because if you kind of from here on, I mean, once the committee submits its report, I guess it goes into a lawmaking process where the considerations are very different. And I just worry that if some of these gaps are left, then they create so much ambiguity that I think it brings the fears that Malvika had pointed out around the increase in administrative rulemaking right to the front of this conversation. I also have some perspective on the sovereign data access, Nikhil, but I'll pause here and see if that's the direction you want to go in.
So, Subhashi, do you see any challenges with the definitions of data, data trustees or data businesses? And how is this the same as how the data trust has been envisioned in the EU, or any different?
Yeah, on the question of the challenges with data trustee, I think I can see, it's been defined obviously as a government or a non-profit, and it's laid out several different kinds of non-profits that can become data trustees. The challenge I see is that in India, this, non-profits and for-profits very often have a very cozy kind of relationship. And I think to that extent, I think there have to be more guardrails around the kind of organizations that can become data trustees in terms of their ownership, in terms of their funding or things like that. Because I think otherwise, given the very important role that data trustees do play, you don't want non-profits that are somehow financially, operationally, or otherwise very deeply affiliated with a certain corporate interest to hijack that kind of data trustee. So I think that would really be my limited point around the data trustee question that you raised. In terms of how similar or different this is from the data trust that have been envisioned in EU, that's not necessarily something I know a ton about, and I think I defer to Parminder and others on this panel for that.
Parminder, what are the differences between the taken here in the EU?
This goes back to what Malvika was also saying. I think everything first hinges on if we agree that on what the purpose is and whether that purpose is valid for this whole exercise, because nobody does any rights making just because they look symmetrical, beautiful, and so on. And then go back to the digital industrialization thing I was talking, and come to the data trust part. Europe, UK separately, France separately, Germany separately, and EU are all very, very intensively looking at digital industrialization strategies. Both voluntary data sharing, and I'll come to data trust as the key part of UK's digital industrial strategy. They don't use the word, they use the word industrial strategy. So in case of digital, it is digital industrial strategy. So one is that trust is simply an infrastructure which allows you, if you are willing to share data, to do it in a more trustworthy manner. And for example, the new Data Governance Act of EU lays down that if you are a data sharing service and you declare yourself as a data sharing service, you have to be neutral, you have to do these things. And these becomes the voluntary systems which are stamped for quality by a government institution, perhaps, which is different from that system also having certain rights to call for certain kinds of data. That rights over the system. One is a system which can help people to share data, and over the top there is a right which ensures that certain kind of feeds flow into data, and that feed, which is the data which is hoarded by the biggest platforms, which is no way going to be brought out simply because you put forward a good trust infrastructure, because Google, Amazon have their own data sharing frameworks, which are by far better than anything which a independent or a government system could put up. They have their data sharing captive systems. So if your main problem is, then the problem statement is important. If it is that society's biggest data hoard right now is with few global companies, which are all US or Chinese, and all other countries, including the EU, are becoming like third world or developing countries or colonies, as the CEO of Naspers said when he was visiting India, that EU is becoming a digital colony of the US. If you think that this data hoards, which are with two poles globally, and rest of the people are becoming dependent, like industrialization did it, they will get deindustrialized, they will become de-digitalized. If that is a problem and you want to get that data out, and then an independent voluntary data trust is not going to get that out. Actually, and this is the paper I'm doing, that trust may help these people get additional kinds of data which they otherwise could not get, because you develop a very beautiful data sharing framework, including Node, on like the government of India's Node framework, which is also a data sharing framework in one part of it. And they can actually plug into that system and actually capture more data which they were not directly able to collect. So if the problem is a asymmetry between these large data companies using data power to completely screw up the whole economic, political, cultural balance of this world, if that is the problem, then the solution is not the kind of voluntary data trusts which the UK strategy, for example, talks about. And the last point before I end this, I must tell you, and I didn't mention that Europe is bringing out laws. They are bringing out a data act in 2021, which it clearly says will define data usage rights between business to business. They are bringing up B2B data usage rights. They already have a Digital Markets Act where the businesses can take their data from platform, including aggregate data can be asked back from the platform. So these mandatory data sharing things are happening in the Europe also. So please go and visit them. And India's framework is doing one kind of it, which complements the ones they are doing. So just to go back to the trust question, there could be voluntary data sharing trust, and there would be added to it a rights-based approach, which says that you can, in a mandated manner, also get feeds from certain kind of data sources, and which data sources are these large platform companies who are not otherwise going to release their data.
So how would you respond to Malvika's point that says that this is the state creating rights for itself, it seems?
Now, this allegation has been made continuously by northern countries over southern countries whenever
let's not get into the politics of it. I'm talking about philosophically.
Nikhil, nothing what we are discussing is non-political.
I understand that.
I may have a difference with you.
I'm saying that sounds like ad hominem. No, Parminder, it sounds like it's ad hominem if you're just saying that it's an allegation they've always made. I'm just saying conceptually.
There is no ad hominem when I criticize a state for being an authoritarian state. So if I say northern countries, there is nothing ad hominem in that. I say state is an authoritarian state. China is an authoritarian state. There's nothing wrong in saying that. So when I say North as a group, we shouldn't be more sensitive about North than we are about China.
I'm not. I'm just saying that
conceptually. I'm just saying North. And
what's your response to the idea that the state is creating its own rights?
Exact response is that whenever we have talked about traditional knowledge rights, whenever we have talked about Convention on Biodiversity, under which Nagoya Protocol, there's always been said that Brazil, India, South Africa have fought, and they said countries want rights, and developing countries have said, no, these are community rights. So this is not a new thing. I understand the danger, and I already mentioned the danger that government can take non-personal data and misuse it. But to this specific point, and there is some not great wording in the report when say India owns its data. I think the India there is the community, and the community should make it clearer. And there is always this thing about whether you are taking a state power or a community power. And I do also see the overlap, but if you ask me the question, how to differentiate it conceptually, that is also possible in the manner I am doing it.
Okay, what about the point that the government seems to have an overbearing role in this entire process?
The role has been reduced by the community rights framework. Even EU is asking for certain kind of data, mandatory data sharing. Some mandatory data sharing is going to take place. Whenever a mandatory data sharing takes place, and EU has explicitly written that there would be some mandatory data sharing. Whenever mandatory data sharing takes place, you will always say that government is exercising its eminent domain rights. I think by putting a community framework, it reduces that fear. It gives us more chances to fight back. It does not completely remove that fear. That's true that community frameworks have been misused. But I think between not using a community framework and using a community framework, when it is clear, even in EU, that mandatory data sharing of some kinds will take place, I think India is contributing something very new, which is not there in the EU, which is a community rights framework. In absence of that, it simply will be mandated data sharing on, at best, the advice of a regulator. That is less than having a community rights framework where even if a regulator is working, there's a lot of history of public trust doctrine, etc. Wherever community rights are involved, courts take a different kind of view about what rights citizens have to push back. And there is this right now with the community rights framework.
Okay. Malvika, do you think that there are grounds for there to exist community rights over data?
Well, so hearing this, it was really helpful, and thank you, Parminder, for those comments, because I am completely aligned with you that all of this there's a huge geopolitical discussion that this is grounded within, and in the international law context or international trade context, I completely understand the idea of sovereign rights, right? But if you step out of international trade negotiations and step into domestic lawmaking, I guess there are two or three things. Your question of can there be community rights in data? Is this a good approach? So if you want to ensure that it's not an extractive digital globalization where these northern countries and their 7x tax resident companies get all the profits from what we're going through. Two things I will say there. One is, if we want to talk about data colonialism or whatever, the fix for that, I fear, it should not be domestic oligopolies, right? Like, we don't want to go from World Trade Organization to I worry that we hold up China and Russia as these kind of paragons that we want to inhabit in, because personally, ultimately, it's like, what kind of society do we want to live in, right? Like, if the GDP of the country goes up, that's great for me, because I presume that will be a GDP per capita increase, or I get better health provision, social provision. And I guess within that political framework, I guess my concern is this community rights framework just going to enable certain kind of data oligopolies domestically to develop and actually change nothing for those of us who are kind of the people who are generating a lot of this information, right? So I guess that is my philosophical discomfort with this framework. And again, the practical reasons why is because of the Section 8 company, the issue that communities often do not self-identify as a community. And that's the huge difference between something like, land rights or any other kind of rights, is that data fundamentally in communities of data sets within high value data. And again, this comes back to the individual, right? They don't self-identify. Even businesses don't often self-identify. So I think that's my issue there. The other thing I wanted to say also is that, I used to work with trusts all the time as a structured finance lawyer. And the one thing that comes back to me personally and professionally is that trusts don't always equal transparency. That's the big, if you look at it purely in form of the form of a trust, it's often something that's created as an intermediate step, which does help liability management and risk management, but if done in a way that is not empowering for the trustees or the people who are beneficiaries of that trust, it in fact can be, it's known world over, right? What are the Panama Papers about? What are all these scams that will come up about? Is about that trust structure. So on trustees, I would say, to make it very specific, again, to root it in something substantive. I don't want to make 20,000 feet statements. When I look at pages 16, 17, 18, 19 of this report, that's where this whole discussion is happening. I think the role of the data trustee and the definition of the high value data sets is extremely open-winded, very open, because it says beneficial public good, but it also has a clause 16, which says and others. And everything is basically a high value data set, right? Like, a high value data set can be anything. And that's okay if it was only data which had nothing to do with the community or was generated by the community. I mean, I would have less of a dog in the fight if this was all just industry to industry data. The issue, I think, is that the reason why this is such a complicated question is that a lot of that information fundamentally does have PII underlying it, or it's generated in relation to anonymization, which I hope we will talk about, because I think the big elephant in the room is anonymization here, and how that will affect not just both these frameworks, but how this PDP and NPD, but how NPD will work. The other definition which we want to talk about is trustees. So trustees, it says a trustee is a data business. Does that create any kind of conflicts? I don't know. The trustee is Section 8 company. The community doesn't self-identify. And I guess broadly, if you look at those pages, these are the kinds of things that kind of, I won't kind of go through the entire list, but I think those kinds of things we need to tighten up, because if we want to start introducing trusts without that kind of tightness, there is a very easy possibility. They have these companies which I shan't name, but every bank in the world has a trustee company, right? Trustee DB Trustee Company Limited, etc. And their sole role is managing trusts in large structured finance transactions. There's nothing wrong with that, but it's a very clearly defined role. They have very little discretion. And to be completely honest, they manage a lot of shell companies. That's basically what's going on. And given we have that experience, can we step into something that's a little less heavy-handed is, I guess, my question back. And actually, I don't know if we have enough time, but can I go into specifics around anonymization, consent, and so on? Because I think this might be...
I think let's just get to anonymization in a bit. We'll just get into it.
Nikhil, I'll just have a small comment on what Malvika is saying. See, we have only given few ways of doing things. If you want governments to take it and say it is a government thing, eminent domain, then you have to have some other thing, which is a trustee thing. Not everybody knows that whether it's a trustee, whether it's an NGO, whether it's an international organization, whether it's a private business, all have their faults. So the question is, between governments and a community trustee, what is the better thing? And second part, you were talking about it will benefit big industries in India. This is an old argument in industrialization policies. When India got industrialized initially, we did a lot of reservation. Leather industry was reserved. Diamond processing industry was a different kind. Whenever you make an industrialization strategy, you always have this thing that, oh, big companies of India, Reliances of this world, perhaps, or whoever is going to benefit and not the small ones. That's always a danger. There's always a blame which all industrialization strategies carry, and they should do enough to mitigate it. But that's a normal allegation. Every time an industrial policy is made, it will happen.
What do you think can be done to mitigate it here, Parminder?
Yes, to mitigate here are subsequent kind of regulatory things. It does keep on saying smaller businesses, preferential, etc., SME support, etc. What is the intention in those references has to be then magnified and clarified into more rules about how data sharing takes place. And I'm very much, for example, I have been arguing on different lists in the way Reliance, for example, is coming together into one conglomerate should be broken up in different manners. So, but there's something subsequent and something basic. Now, if we bring downstream arguments to an upstream formulation, then it kind of muddies some of the basic concepts. And that's my problem, that's all.
Okay. Subhashish, does the definition of a trustee as a business create any conflicts in your mind? Like, do you see any conflicts?
I'm very sorry, Nikhil, that's the question. I think when she says it is to be a data business, Malvika, that is only for the purposes of transparency obligations. So it is not considered as a data business. I think it should be made clear. The committee did not want trustee not to have the same transparency obligations that data businesses are to do. And it is only in that sense it says that all transparencies which are put on a data business are also applicable to trustee. I'm sorry, that was the connection. Sorry.
Subhashish?
Yeah, Nikhil, with that clarification, which I kind of expect, was thinking would be the point. I think I don't necessarily see a conflict apart from the fact that I think there need to be some guardrails put in place to just make sure these trustees aren't overtaken by some sort of corporate interest.
Is there room for the improvement in the definition of a data business?
In the improvement of data business. So what I said was in regards to trustees and saying that certain kinds of trustees
and data trustees for that matter.
Yeah. On data trustees, I think the only improvement I would suggest is to say that your ownership and your other kind of operational links with any other groups, and especially those who might benefit from the creation of this HVD, should be tested, because you don't want that kind of conflict of interest. Data businesses, I did have 2 points, but just before that, I think the last question to Parminder about some of the functioning of the data trustees. And I think the 3 big things that we should do to make the data trustees better is, firstly, I believe there should be greater transparency, which Parminder is saying. I would have loved to see something along the lines of, as a data trustee, you should have an obligation to bring out some sort of an annual report every year which says which HVD did you create, who had access to it, did you deny any requests, those kind of things. Because if you are representing the community, then I believe you should have this accountability and transparency towards the community. Secondly, because the data trustee basically has this massive power to go and ask anyone for their data. And this is a little bit to one of the audience questions around incentives. Like, there's no incentive, it's an obligation, right? If the data trustee comes knocking on your door and says, give me that data, you should give it, you have to give it, or you have to go and contest it. So in that contestation process, I think it will be important for there to be an independent judicial arm to it, because typically, again, in Indian regulatory governance, we just haven't had it, which results in all kinds of bad judgments. And thirdly, I think as a matter of principle, the data trustee should not be, I think the big point here is the non-discriminatory aspect. And I think it's a good thing that you cannot, the data trustee cannot discriminate against incoming requests. And I think it should be enshrined more so that as a matter of principle, you should be approving each and every data request that you get. If you have a dispute, you go and take it to, as a data trustee, if you really dispute it, go and take it to the independent adjudicatory body. I think this takes a lot of the discretion out of the data trustees, and I'm therefore hopeful that it'll address some of the questions that Malvika has raised. About data businesses, I was just a little confused by it, because clearly it says that data businesses, there are certain thresholds that will be defined by the authority above which you become a data business. And then you have to be a registered data business, where there are more grounds for thresholds to be created. I wasn't very clear conceptually what's the difference between the two, and who has the metadata, mandatory metadata obligation. So if that is data businesses, then what even is the point of registration of data businesses? So that just wasn't very clear in my mind. Are these going to be two different thresholds? If yes, who has the mandate? Who must mandatorily share metadata? And what is the role of registration if it's all data businesses, which was one of my interpretations.
Parminder, would you like to respond to that?
I think every business who does NPD is a data business.
But effectively, every digital business does NPD, right?
Yes. And therefore, but registration obligations are placed only above a threshold, where the regulation will be looking at them as a data business. So one is conceptual definition, and other is under the remit of the regulation, that which crosses certain thresholds, they need to register, and the regulatory spotlight would only be on them and not those who are outside. Though they may be called data businesses, but I think I understand why you are saying, and they should be clarified that only what you have to have for regulatory purpose, call that term only that, and not all businesses. Yeah.
So if I could clarify that, Parminder, what you're saying is that only registered data businesses must share metadata, not all data businesses.
Right.
Okay. Then then the question becomes, what is the point of those thresholds that will be set by the authority, etc.? But I'll see this based on
that threshold is what makes you a data business who has to be registered. Below that threshold, you do not have to register and do not have to comply with the regulatory requirements at all.
Okay. Sorry, I thought we'd lost connectivity. I'm just going to move to the last 2-3 portions before we take questions. Firstly, on the public good purpose, how do you define public good in this context? Malvika, do you think that there can be an improvement there? I mean, how is public good defined in the first place? Who defines public good?
I guess this brings us back to what we started this discussion with. I'm very keen, and I would love to get clarity maybe in this conversation about what are we talking about when we say community? Because I think that is something that we need to use as a lever when we start defining public good. So clearly there is an interest around the community and an interest around Indian firms. But right now, I can't see there's no definition. Like I see the word, and correct me again if I'm wrong, Parminder, but it's a very broad definition right now.
So is public good defined under law?
That's the thing. It's not, there's no one, and it also depends on the discipline that you're looking at this in. It would be totally different, right? And I'm not sure exactly whether you can call this a kind of, we can't go into constitutional jurisprudence, I don't think, for this, because it's across the board. It's a private, you're creating a law that governs loads of entities. So yeah, in my limited understanding, this is a broad term which will require construction along the lines of what's this law is doing. And I think that's why we need clarity on objectives, because this will be interpreted in relation to the objectives of the entire legislation. Like it can't just be public good for something totally disconnected from non-personal data sharing or the related objectives of this legislation. And that's why I think that needs to be clarified. I'd really love to get clarity on what do we think about this community issue, which I still think is inchoate. As far as I can see, who is the community here, and how would they self-identify and organically create a data trustee?
Parminder, did the committee consider or debate the definition of public good and consider narrowing the definition of the word community here in this context, or is it meant to be broad and so that everyone can participate? How does this work?
Community is what it is, as I've been discussing, partly is a legal fiction to get around collective sharing of data. I'd come down to it later. It's a longer discussion. I'll go back to the public good and the public interest question, which is key here. Because now the change of architecture is that there is an interposition of public interest and HVD sets which are of public interest rather than all B2B data sharing. Now, public interest has always been open. The whole idea of a political process, it defines public interest on and on in different situations. And let me go back to how resources, even private resources, can be expropriated in the name of public interest. There is something called standard essentials patenting. Some standards, if they are essential in public interest, it can be said that they will be available on a FRAND basis. Now, what is public interest is in that context determined by that standards body or those bodies around it. In public interest, again, compulsory licensing against patents can be done. Now, what is public interest is always a time-to-time determination. In this context, whatever guidelines are available, and this was the thing I was discussing when I first spoke, is seeing data as infrastructure. A lot of data are infrastructure, and somebody was giving this example that if somebody a lot of businesses who need microclimate data for their working. Now, would it be necessary that every one of those businesses have to set up a weather station because all of them need microclimate? And if some micro stations do exist, whether that data should not be considered of an infrastructural nature. Now,
but there are businesses that sell that data, right? Like, for example,
I'll come back to that. I'm just saying what is in public interest. I'll come back to whether infrastructure could solely be private or not. So certain kinds of infrastructures are considered public interest, certain kind of transportation data, certain kind of weather data. So the public interest here will be if it is considered that certain data in a certain sector is considered of a cross-cutting infrastructural nature, where traditionally governments had come in the industrial society to make roads, to make ports, to make various kind of infrastructures, which was generally a public infrastructure on the top of which private activities used to ply. The real problem globally today is whether the social media problem or data problem is that large digital infrastructures and data infrastructures have been captured by a few companies, and the difference between infrastructure and suprastructure does not exist. The issue here is the public interest determination is whether a certain kind of data is considered of an infrastructure quality in that sector. That public interest determination, like in standards, like in compulsory licensing of medicines, will be made by a certain ecosystem on a case-to-case basis. This is a definition of what would be the nature of public interest determination in this system. We can go to specific questions after that. Yeah.
I understand. Can you run a logical flow regarding how this entire process will create more economic activity? Can you give us some examples of, let's say, businesses that will benefit from acquiring some HDVs?
See, there's a lot of examples available. For example, in health data, a lot of NPD about, say, just cancer patients and X-rays or other radiographic information about certain kind of patients, which is available in a non-personal data form, which is being made into certain kind of shareable data in Europe and other places. There are certain logistics and transportation data, which are very fundamental, and a new business can only come into existence if that is available to it, or otherwise it would have to ride an existing system which is already under like Google Maps is with Google. So certain kinds of and I mean all sectors, you name the sector, health, education, transportation, certain kinds of data are necessary for any company to come and do meaningful digital business in that sector. This would be a determination. And examples are there in the report itself. I can be giving more examples, but
Fair
we
enough.
will always differ on them. Yeah, agriculture example, soil conditions, crop
Malvika,
patterns. Yeah.
sure.
Actually,
Malvika, you
I'm
wanted
just
to talk about anonymization.
Yes, I did. And I just wanted to say one quick thing on this. I think the third model that we haven't discussed, which all the words that we are talking about, market power, public interest, abuse of power, and so on, these are all very classic antitrust terms. And I think that's the third model that we haven't. So it's not often so binary that it has to be between a state doing it or a foreign organization coming and taking on the data. Actually, having really strong antitrust laws, and if we look at other countries, including what the kind of Biden administration is taking on in the US, I think the best way to deal with this without creating large public state interests, which could be arbitrary, is to really think carefully about what is the role of antitrust in all of this.
But that Malvika typically relies on market failure having taken place, right? And here I don't know if there is a determination that there is a market failure, but the mechanism to address market failure seems to be put into place with this report.
No, actually, there is a lot of work in antitrust currently. There's an excellent book on the misuse of market power in data. And that is the basis on which many countries are proceeding. Not to say that we just cannot do something India, that is exceptional to other countries, because currently we do want to seem to create our own leadership on these issues. But the fact of the matter is that antitrust is thought about, just like in the industrialization era in the US, around all when they were creating their large public public infrastructures. That's when antitrust came to the fore and really created a very vibrant economy with good outcomes for consumers. The EU has done it in different contexts. And I think the kind of failing for India really is that we are having this huge industrial moment and we haven't seized on that to create strong antitrust frameworks, because the same incentives that it doesn't really matter, does it? That public-private service provision, I think the incentives for hoarding, creating not great welfare outcomes for individuals, I think those are the things that antitrust addresses. It doesn't make it personal about, are you a private sector actor? Are you state? Like, no one is inherently good or bad, right? You can't rely on good intentions. What you can do is set up good incentives. On the point of anonymization. Yeah. So there are 2 or 3 things that I was really keen to kind of discuss on this panel. First is that I think the way that anonymization is dealt with in this report, I'm really hoping that it can be broadened a little bit, because my concern is that it sets up a kind of regulatory arbitrage for companies, which could either register to be data businesses under this framework, or data fiduciaries under the PDP bill. And the issue there is you really don't want that trade-off being created for companies, because what it then does is it creates a situation where regulatory authorities are in conflict with each other, or at least in some kind of competition for regulatory space. And that might actually adversely affect the provision of digital services. I think many may prefer, if this framework turns out to be a little bit more overbearing or unclear, or a lot of the other issues, many may prefer to fall within the PDP framework, given that it's so far along in the process. And what that means is people might, there might be a disincentive to anonymize, which is actually a real, that's the whole of data security, data protection, all of these years, what we've been kind of looking for is to create better, stronger anonymization to protect human beings ultimately, right? No safe human beings, no data markets, no nothing. I think the related point here is just the way that that's been dealt with also, I really fear is kind of throwing communities or individuals to the wolves, because we know that saying consent to opt out of anonymization. So we have this vision here saying that, as an individual, you have to decide that if you want your protections under the personal data protection bill, then you have to opt out of anonymization, and therefore you get from the company. So as an individual, I need to know both the new non-personal data framework, the PDP framework, and then decide to opt out or choose one or the other. Now we have so much Indian data, right? We have the NIPFP study on consent with, kind of people who have tertiary level education. There's a bunch of stuff from Bosara that's come out. I know that Omidyar is involved. Yeah, just, opt-outs have never really worked. So I think that's kind of, I wish that we would take a bit more of a truly community or responsible turn there. And the last, I think, question that again I wanted to raise, and again, none of this is personal. I'm not making no allegations. I'm just raising serious problems that will affect you and I and the country that we care so deeply about, is metadata, right? Now we have, I went and looked at the Aadhaar judgment 470 to 471 pages. Specifically, we understand that metadata in the Indian context is an extension of it is personal data, right? And this is widely recognized around the world. And it's accepted not only to fall within personal data regimes, it's also recognized to be highly sensitive because of the data aggregation and other issues that come up with it. And I think the treatment of metadata, we can't go into it in a lot of detail right now, but this report squarely deals with that and seems to take set up rules around how metadata is managed, directories are set up for it.
But
And,
to be fair, Malvika, it seems to be that that the directories are being set up for metadata about metadata.
About personal data,
yeah, but like I said, now this is having talked to a few people.
And in that case, is there a need for a definitional change, or a narrowing of the definition?
So this is my question, right? So we, after many of us who have been reading the report, we come to this understanding, oh, they don't mean metadata, but a directory of metadata. I'm not sure how many of the audience, for instance, have clocked this. So I think one thing is just in terms of nomenclature, when you say data business will share metadata and underlying data under appropriate regulations, metadata refers to data that provides information about other data. Like this is all from the report.
Yeah.
This to me describes metadata as I understand it. And there's, fair degree of clarity around what happens in that framework. Now, if we want to be talking about some other concept, then I think we should just call it something else, because when we talk about metadata in this way and then set up rules, it's definitely going to create some dissonance, is my kind of short point.
What kind of harms do you expect if there's open access to this metadata? I mean, it's just name fields, right? It's not data itself.
Okay, so two things here. At one point of time, we say somewhere that there's non-rivalrous use of this benefits everybody. Now, the question of harms is one thing that it's a really wide debate. I think the edge of that debate is that we know for a fact that when you have particular types of data aggregation, you can find out about individuals. So that's inference-based data. Now, when you say here that if I have between companies, I have a directory of their metadata, it seems to me to be reproducing some kind of a regulatory proxy problem, right? So that proxy problem that we all think about in data protection, sorry to pull from another field. So we say, oh, somebody doesn't want to get X data. So you try and engineer that data by collecting 3 other fields about them, right? And you say, okay, so therefore you can't, and so going through iterations of this, we've come to a point where we say metadata also reveals PII if aggregated. And it now seems to me, and again, I don't have, I know, I'm not answering
you have a solution
committee, but I'm saying like, why are we going down this path of like saying, okay, if not metadata, then directory of metadata? Because if the definitions are clear, that everything that is non-personal data is outside the PDP bill and mixed data sets also are not within NPD. This is the other big, along with the idea of community, the other big question for me is really conceptually what is left, like what is NPD? And is there a kind of attempt to, define something as NPD, which is not, basically.
Would it help if this data didn't pertain to individuals?
But how would that, I'm just wondering, how do you mean? What kind of, because it says
weather, traffic patterns.
Yeah. And that's the thing, right?
I mean, for me, for example, food preferences in a particular location don't necessarily pertain to an individual, but they can still, that data can still be misused.
No, and
can cause significant harms.
Yeah, and this is also like I'm trying to think about this in a principles level as we started this with a technological neutrality, right? Because what we think is the state of the art, like today you might think that's fine. It really depends about data aggregation and data mining, right? So today you might think food preferences is fine, which is how we got to metadata, right? After Snowden, after all these years, now it's been however many years.
Yeah.
Things that appear to be not sensitive. It's just a question of how they are combined. Now, again, I'd love to have a discussion since, on this whole directory point and how that directory of metadata, is it really so safe and is it not metadata? But I think my short point here is then we should call it something else because the way that we're dealing, the description of metadata and the treatment of it in this report, again, creates a lot of regulatory kind of overlaps, skirmishes, and so on.
Subhashish, any responses to what you've heard before we move to Q&A?
Yeah, just 2 points that I wanted to pick up on, one smaller than the other. On this question of metadata, I personally, I think given it's a directory of metadata, at least the function that I see for itself in this entire ecosystem is to enable data trustees to actually know what kind of HVDs they can create. So if they don't have that, they'll never know who's having what kind of data, and therefore how can I combine it. Again, my problem with this, all of my concerns with these reports are the details, and therefore it wasn't clear to me why this metadata directory should be open to everyone. It should then be open only to people who can potentially create HVDs, which means it shouldn't be open to other businesses. So I don't know, that I think just if we make these kind of tweaks and make sure that the metadata directory is only open to potential HVD creators, then we minimize the surface for all kinds of harms. In terms of, I don't know if being under PDP and NPD was like a either or kind of situation for businesses in any way, because given the references to harmonizing the thresholds with the PDP, the sense I got, and Parminder should correct me, is that any business would be most likely be regulated by both of these. So I don't think they'll be able to create that kind of regulatory arbitrage to say that, look, we don't want to be under NPD, so we'll not anonymize or that kind of thing. And I think some concerns have been raised about the opt-out to anonymization, and saying that, look, is this going to reduce the incentives to anonymize? I do feel that that is probably the reason, and again, I'm probably speaking on Parminder and the committee's behalf, that the committee decided to make it opt-out, so that, because if you made it opt-into anonymization, then people would probably not, people don't change default settings. So to that extent, I think that would be a way to ensure that anonymization does actually happen. So in that sense, I wonder if the concerns around some of this regulatory arbitrage in this case might be a little misplaced. So that's my reaction, and stop with that.
I'll just put in a word on the fact of metadata is an English term. Its meaning is, if the data about which metadata is of a certain quality, it is about cows or oceans, then the metadata cannot become something else about people and others. So here the metadata was just to say that, and this is also, businesses would be asked to make certain kind of data processes transparent, the nature of the data processes, and not the underlying data itself being transparent. And just to make that distinction in a very legitimate use of the English term, it says the metadata means the nature of the processes, not the data itself, would be transparent in a registry, but the data itself can only be asked for in that HVD process. And between, again, NPD and PD, there is no arbitrage. A piece of road is subject to about 10 agencies regulation at the same time. One cannot say I'm subject to environment regulation and therefore I will not be subject to PWD's some regulation or traffic rule regulation. It doesn't happen. Both regulation are subjecting anything to the extent it is subject to that. So I think there is no arbitrage between the two at all. That's all, Nikhil.
Okay, we have a bunch of questions here, but I think we'll have to rush through them. Aditya, over to you. And in case anyone has a comment or wants to make a statement on anything that's been discussed in the session so far, please do raise your hand, and Aditya will take over. Thanks.
Thanks, Nikhil. So yeah, we've had quite a few questions, and I'm sadly I don't think we'll be able to answer all of them, but we can definitely try. So first, I'll take a question from Kiran Gopinath. Subhashish, I'll come to you, because one of the things that you had earlier mentioned in your initial remarks was that you had basically speculated that the committee's motivation could be to try and bring in this large amounts of data into the ecosystem, and so that people, because businesses themselves do not have the incentive to derive value out of them. So in that vein, I'll put Kiran Gopinath's questions. So if I own, basically he's gone with the NPT's definition as in, if I own a machine that generates the data, shouldn't the data be mine or my company's? So essentially it's basically like companies themselves see a lot of value in their data, so why should they essentially share it? So Subhashish, if you could comment on that.
Yeah, no, thanks for that question, Aditya. I think at a pragmatic level, even the committee's report acknowledges that look, jurisprudence will evolve through this. This is going to be, if this is enforced as it is currently envisaged, there's going to be just a lot of litigation, and all of these questions will be defined. And I think they therefore lie on that kind of boundary condition. As a matter of principle, if one asks me if I own a machine, it's just mine and it's generating certain kinds of data, uh, should that be subject to this kind of NPD discussion? My inclination towards that is look, if this is a commonly used machine which is relevant, which is going to provide information that's relevant for quote unquote public good purposes, and there are 15 purposes that are defined in section 7.6. So if someone can draw the link between the data that this machine is generating all the way to that public good purpose, then I think it is fair game in that sense.
Thanks, Subhashish. We have another question. I think I'll first go to Malavika and then maybe Parminder could take a shot. So you've spoken about the community aspect of it and how communities determine themselves. Like, so a question from Abhishek Jain reads: how will the gap between citizens and data trustees be bridged and the information asymmetry be reconciled? So you had commented on this before. Could you add on to that question or take a shot at answering that, Malvika?
Actually, this question is, I'm still wondering about this as well. Currently, I don't see any direct safeguards for this. And I think that's where the concern is coming from, is that somebody acting on behalf of a community can actually end up entrenching that distance. But yeah, Parminder, I'm sure you've thought about this more, so over to you.
Yeah.
Yeah,
Could you? Yeah.
Permits. Yes, I think that we were in a NASCOM interaction 2 days back, and this question came up, and also a very senior member spoke about data governance, about governance of trustees thing, and I think I answered there also. Is this now the single most next thing to be done is the governance of the HVDs. I completely agree with all what you are saying. But again, I'm going back. There are certain upstream principles and there are certain downstream things. There is a hierarchy in way internationally things get done. Now, establishing a community rights framework gives you many more ways to do what you want to do. For example, a very senior member of the committee was saying that there should be public consultation when HVD is made, etc., etc. There can be many things because a community framework exists. Now, if we just jump that community framework and say we don't care about it, then it goes back to the eminent domain framework. Even there, you could have those things. But what I'm saying is that we have tried to put upstream principles and possibilities which allow downstream works of this kind to be done. And I'm completely in agreement. One of the biggest things to be done next, and I even agree, and I think this should be part of people who write back, is that please write a little more about the governance structure of the community trustees who manage the HVDs. And I think my personal view is a paragraph should be added to that.
Thanks, Parminder. So we have another question. I think we've briefly discussed upon it, but are there any? This is a question from Saranya Gopinath. So, are there any end use restrictions on a data requester? Any of you could take a shot at answering that. Subhashish or Malvika?
Sure. As currently laid out, there is the report alludes to public good, but it is not defined how giving the data and after giving the data you ensure that. So there, at this point, it doesn't seem that there's much of an obligation there.
Yes, there isn't. I mean, let me come, because this was a clarification which Nikhil and I on earlier discussion were doing, that once, and it's like an infrastructure. And that's why I keep on saying, you want to understand what is happening there, think infrastructure. A government makes a road. Now, road is made for industrial development, people's good, etc., etc. But road is an infrastructure, and you will use it for other purposes, many purposes, as long as it's not an illegal purpose, right? So generally, once a thing has been given the status of infrastructural data, it says all entities, not individuals, can ask for that data, and they can do business with it, they can do many things with it. It is considered to be in public interest in the sense that a road is in public interest, or a bank is in a public interest, or other kinds of public infrastructures are in public interest. So there is no real constraint other than illegal uses at present, as I see it. It's like a road now as an infrastructure.
Thanks, Bhavendra and Subhashish. So we actually had a question from Sakshi Agarwal, who we've actually upgraded as a panelist. Sakshi, are you available? Would you like to ask your question now? Okay, I think we'll move on. Again, there is another general question that had actually been asked in the initial part of the discussion, as in, what exactly is like, what are the incentives for voluntary data sharing in the first place? I mean, we have an entire framework in place now. So, what are the incentives for voluntary data sharing? Parminder, if you would like to answer that.
This report is voluntary data sharing plus. It doesn't deal with voluntary data sharing, other than the fact that it does set up very sophisticated and I hope technically capable systems of data sharing. There are technical advices in the report how data sharing should be made, what are the minimum security protocols, etc. And it is true that the same HVDs who may be accessing data under this framework may get contributions of a voluntary kind, and which will be very good. For example, somebody is holding transportation infrastructure data of Delhi, is getting certain contributions which did not come in their mind as an HVD data set, but somebody is voluntarily contributing it. There's a lot in the report which talks about minimum technical requirements, security requirements, duty of care. And in that sense, that trustee is also a data business and therefore has the same kind of duty of care as a data business has, plus more, but at least that much. So this duty of care, etc., all those things are provided and therefore does make it easier for somebody to voluntarily contribute and share data as well.
Okay.
So Aditya, I'll just take over. There's a question from Siddharth Manohar. Says that as per the report, a data community raises concerns for redressal through a non-profit, which is equivalent to a trustee in the description, but isn't called a trustee explicitly. So a data community's trustee would be a different organization from the one to be approached for grievance redressal. Isn't this an incongruent system? Why can't trustees be given the sole responsibility of carrying out this function to remove ambiguity?
Sorry, Nikhil, I think I'll have to answer that, though you may ask others, because it's a framing issue with the report. I did mention earlier that there was a deliberate separation of two aspects of community rights: one, harm prevention, and other, benefit making. And it was found that harm prevention is a different kind of thing, which it should be easier to report and complain, which you have to say, no, this community, like you were saying, because somebody eats more, let's say, biryani in this area, this is being misused for whatever purpose, and there is certain harm in putting out certain kind of data or whatever. That can be done by many organizations because it's simply a complaint which will be educated, right? Which is different from beneficial use of data, which requires setting up an HVD, having the so-called authority to ask for data from other people in a mandatory sharing. So that purpose is more sophisticated and complex, and therefore requires more qualifications than just to register against prevention of harm. It's deliberately separated so that if we just only allow trustees to be able to complain for harm, then some other people will not be able to complain on harm on the basis of a community, which is being therefore making a more harm prevention kind of complaints possible. Therefore.
So there's a follow-up question. Data businesses have a one-time registration only. Wouldn't it be better if they have a licensing regime so that if they fail to adhere to certain standards, the license can be revoked?
That would be simply a little harder, harder regulatory regime, which the committee did not want to go into licensing. This was discussed that it is actually, I think it's mentioned in the report that it is not a licensing, but
I understand. The question is why not? Why not a licensing framework?
Just to keep it lighter. That's all. I mean, both kind of regulatory systems work. This is a lighter regulatory system. That's all.
Okay. Question from Urvashi. What would you clarify as data infrastructure? Would you clarify what constitutes data infrastructure?
Okay, I did mention it earlier. I'm sorry. Any data which becomes necessary for any company to come up and start delivering data-based digital services in that area. Increasingly, as we get digitalized, there will be certain kinds of data set you can't enter into the market. It's like if you don't have access to road, you can't even start a shop. So you don't have access to other kind of banking infrastructure, etc. You can't start shop. So certain data would be recognized as more or less essential for startup activity to even start or take up or develop. Right now, they have to in some ways depend on these mega companies. This dependence is being cut. So data infrastructure is any infrastructure so defined as a necessary layer of data, which is more or less necessary for doing business in some area.
Okay. Keshav Dhakar has a question. Keshav, would you like to unmute yourself and ask that question?
Yes. Sorry, I thought it was just I had to just raise it. It will be asked by maybe Nikhil or someone. So no, I think I was just curious about. I mean, open data platform and open data policy for the government has existed for many years, right? And this was sharing between governments, state to central to state, or public sector units to all. I'm just curious what lessons of success, failures that has been taken into consideration to learn from them, to say now we need NPD for all the industries to participate, in a public-private collaboration way. Because to me, every single business today is becoming a digital business, and every single business which touches or uses digital technology is generating data. You don't have in a data per se business to say I'm a data business, because the minute you use digital, cloud, AI, anything, you're generating data. So I'm just thinking, what are the government lessons that we have learned, because open data platform exists for so many years now, that could bring into a law, a public-private law framework to kind of learn from them and drive a national level governance around non-personal data. So, Parminder, I don't know if you would be the right one, but I think I would probably, maybe let you have the first say in that, because you were part of the core committee.
Okay, I think again, I would quickly say that the nature of the problem and the solution for open data sharing, and you partly said it yourself, is quite different than the digital industrial problem and likely solutions that this committee was into. Having said that, we did have, for example, NIC in the committee and others who know about technical issues which have happened about sharing, security issues which have happened about sharing. And so those kind of things, security issues, technical issues, etc., were taken on board. But the problem and solution wise, it was slightly a different kind of a context than open data platforms.
Nikhil, if I might jump in with a couple of points there, at least the two
Sure.
big ones that I see was, firstly, it was not legislatively mandated. It was a policy of the government. So to that extent, it didn't have legislative backing. So I think this one is intended to have legislative backing, is what I read in the report. The second one was there was no incentive. It wasn't mandatory, no incentives, no accountability. It was up to the will, the ability of the chief data officer in each of these places. So to the extent that we can kind of firm up some of these incentives and accountability mechanisms, I think this could be a fundamentally different one.
In fact, Subhashish, we tried to use some of the data from the open data, the portal that the Indian government had, and frankly, especially telecom data, and we found that it was outdated most of the time. The TRAI in a non-usable format in PDFs had updated data, and the open data portal would update it like 4 months later, 5 months later.
And if I can just quickly come in and add also a couple of models that I've seen, which are interesting for reference. So one is, I think there is a design choice here. In a lot of countries, there is data sharing infrastructure, but by no means is it always public data sharing infrastructure where the public itself sets up. A lot of people set up regulations and then it is enabled directly. The government doesn't take up a stake, set up a regulator. So that's one model. More specifically, I recommend the ACCC, Australia's Digital Platforms Inquiry, which is super interesting take on basically how do you ensure that market power and innovation and all of these things happen and consumers are safe. So I think that's probably an interesting model that we've kind of missed a trick on, in that if you want to incentivize voluntary data sharing in a safe and secure way, but you also don't want to create this concentration of powers that, is clearly the concern over here, you can use certain, they've done 3 years of work on this, and their report was published, I think, in 2019 or 2020. And then lastly, I found there are certain things like FinData. I think this is one of the Scandinavian countries, but also I think, if I'm not mistaken, I'll send some of the links. They have set up public data sharing platforms. What they've done really interesting is think about a liability management framework as well. So not only does a public entity then take the responsibility for managing and enabling. So it's kind of fully in. It's actually managing liability, and it says that if anything goes wrong, here's the liability and here's the risk management framework. So that's sort of three models that I've seen. One is the FinData, please check it out, Finland. The other one is the digital platforms regulation, where you think of the platform as the infrastructure and you keep data separately, because data has individual rights or company rights, and then it's the platforms that have antitrust regulation. And then of course this whole idea of the public sector is not building the data infrastructure, but in fact it's just regulating and setting the rules of that data infrastructure.
So we need to end this session. I have one very quick question which might have a longer answer, Malvika, for you. How would you, if you had to, what sort of oversight mechanism would you put for sovereign access to data?
Tough one. I think, so right off the top of my head, to give you a tangible answer, the closest thing I've seen, which didn't work out very well, is this thing called the Privacy and Civil Liberties Oversight Board, even on the national security side. So I think there are two things that we need, where it's not national security type sovereign access. It should be held up to a high degree of judicial oversight and scrutiny. That's all we have. Where it is national security, even then, and that judicial oversight means, the people whose data is being taken, the companies, all of them have to be involved in the process, and you have a clear oversight process there. Where you cannot do that because it's national security, you actually have a oversight board that is constituted, but outside of the entity that is managing this entire field. So in the US, for instance, where they had the PCLOB, I think it came straight out of a different department of government, but their whole, which is not the home like security department, and their only role is to go over these kinds of requests, different from the FISA code. But yeah, I think it's third-party judicial review or administrative oversight.
Okay. Well, I guess national security is as well defined as public good is, perhaps even, or maybe not. Thank you, Malvika, Parvinder, and Subhashish for this session. I think it could have been a longer discussion. There's so much to discuss here, but thank you for your time. Please do stay on. We're going to move to a discussion on businesses and their relationship with this entire framework. Over to you, Aditya.
Thanks, Nikhil. So yeah, so we want to talk like the first session was more of a conceptual exercise of understanding the NPD framework and the revised report. This particular discussion, we hope, will try and explore how businesses look at this report and what they think, and if they see any compliance burdens or if they see any problems with it as such. If the other panelists could kindly switch on the videos. Hi Jyotsna, hi Prasanto. So we will probably also have hi Panduranga. So we will probably also have another additional speaker join sometime later during the session. So Panduranga, I think we only have you for a small amount of time, so we'll try to make the best use of it. So
no, it's all right. The other meeting was deferred, so I'm available for the session.
Okay. In any case, we'll start with you if possible. So could you tell us your broad takeaways from the revised report? Like, do you see any issues with it, or what are your general views about it, and then we can take it forward from there.
Great. Thank you. If you were to ask me, I'm very happy about this revised report. So there are many points but primarily, if I were to say, the overlap between the PDP and NPD with respect to the definition of personal data, mixed data sets, and other concepts have been clarified to a much greater extent. I think it is great thing. And then specifically, the report also recommend deletion of sections pertaining to the NPD sharing with from the PD people, and most importantly, deletion of section 91, which mandates NPD sharing with the government. So these two are the important takeaway for me. And otherwise, overall, I see the language and also on the approach of the note has been mostly towards the public good. That is also like gets more trust from the business as well as the community. These are the important aspects when I see the new revised report. Aditya.
Okay. In continuation, do you see any like compliance burden? Because in the previous panel we had talked about how the coexistence of an NPD and a PDP framework. So do you see any compliance in terms of that? Could you share your thoughts with us?
Yeah, I mean, there were many aspects on which we were discussing earlier. We wanted this ecosystem evolve by itself, and then there should be a commercial incentive. If the entire system works as a data exchange, and where companies were to share this information or non-personal data, where an opportunity of monetizing it will only help the system. I think to a greater extent it is achieved, where the private parties, sharing of data between private parties has been outside the purview of the regulator at this point in time. At least a recommendation is made to that extent. But I still have, the question on the sharing of NPD for the public good purpose. Now, there is no powers or reason for any data businesses to say no to sharing that information, because there is no mechanism as to understand what is public good, and if that public good has to satisfy the data business before it shares the non-personal data. But that clarity is lacking. If that clarity is provided, that will be more helpful. And in my opinion, we should empower these data businesses to say no, and such data information which is sought under the public good category. Data seekers should also have an opportunity of reaching out to the authority, NPD authority, and the authority should be in a position to decide on the matter. And it should not be like an automatic or a mechanical process where under the category of a data being shared for the public good purpose. This one is the important aspect that I felt. Number two, on the consent regime. I would rather put it from the compliance perspective for the startup. We were to talk about all these, conditions would work very well and would be much needed from general reading of the document when it comes to this data businesses being bigger. There are small startups who are also would be categorized as a data business. In such cases, there is absolutely no reason as to why they have to shell out more resources and finance towards building compliances around it. It's going to be very difficult for small businesses, more specifically startup in general. And one of the reason being the cost of compliances and the resources they'll have to put in for the compliances. When I say I'm not touching upon all the compliance requirement because most of them are operational challenges. I would touch upon one important aspect, which is consent regime. When a consent regime is such that where a customer, the data principal were to ever make a choice to opt out when they were to share data with these data businesses, from that data being anonymized for non-personal data purposes. Now, this is kind of a bipolar consent system where it works very difficult for the companies, number one. Number two, I am not sure whether government would want to really achieve what they wanted to achieve when they were to give an option to the data principal to opt out from the NPD option, so that these NPD may not have full data or the relevant data set for the public good purposes. Can this lead to a multiple compliance requirement for the startup? I think this would either lead to lot of compliance for the startup, or will have no purpose, intended purpose achieved. When I say a lot of compliances to the companies, startup companies or the companies were to ever spend, would be to manage this information, have separate data set pools where certain data cannot be used for the public or business purposes, but use it for the public good purposes, where certain information which is important for the government, right? Assuming some social welfare scheme has to be implemented, such information cannot be implemented unless this data set is comprehensive, which is unlikely to be if in case the data principal is given an option of opting out of from that concept. So largely, like, this has some operational challenges. Would I suspect that it would lead a lot of compliances issues, Aditya.
Okay. Thanks, Mantak. I hope we can answer some of those and we can get more clarity through this discussion. So we'll move to you there, Sindhu, obviously, because like in the previous panel where Parminder got a lion's share of the questions, I'm sure in this panel we'd expect something like that, since you've been involved in the report preparation. So if you could give us a few, if you could tell us about the major touch points that you wanted to deal with through this report in the context of how businesses will find it easier or difficult to operate in the future. If you could share your views on that.
Yeah, thank you, Aditya. So let me just lay out three main aspects that I see in this revised report. That is a touch point between the businesses and what the committee is trying to do. So the first one is obviously the data business, right? So businesses above a certain size, which would be decided by the NPDA, and there are some guidelines in the report. So they would need to register as a data business, and this is not a licensing. It is just a one-time disclosure that these large businesses with the data need to do. So the second aspect for businesses is that they need to share NPD with the data trustees and for a public good purpose. And I mean, this is probably really the crux of the the recommendations of the committee. And this ensures that Indians have access to public good data being collected by different entities, both private and public. And this is not businesses sharing proprietary data, and I think that's pretty important. It is just data that they're collecting from from India, from Indians, from the community, and not business related IP that that they create. And obviously, there is also this aspect of any concerns that businesses have to share data, and they can approach the NPDA and say that, hey, this data trustee, wants me to share this data, and I'm not sure whether this data is appropriate for the, for the HPD that they are creating. So I would like to, get to you and say that, I'm not comfortable sharing this data, and the NPDA will adjudicate on that request from the data custodian or a business here. And the final point is in terms of businesses, especially those registered in India, big and small, having access to these HVDs, right? So there might be interesting opportunities that might arise when businesses, especially small Indian businesses, combine multiple of these high value data sets, and they might get insights on on the market, on their on a segment that they are looking at to enter and grow. So I think these are the three main touch points that this committee's report has on businesses, Aditya.
On a tangent, one of the first things that you had mentioned was that the data businesses above a certain threshold will have to register as data businesses. And this is something that an attendee had asked in the previous panel, and we weren't able to answer that. So if you could share some thought. So what about the businesses that do not cross this threshold? Do they have? Is there any accountable? Do they have to adhere to any accountability standards in terms of processing or sharing NPD?
See, right now, I think what the committee has mentioned is that the NPDA will come up with those threshold levels, and businesses that go above that threshold level need to register with the NPDA as a data business. So there is no requirement at present for businesses that fall below the threshold to register themselves as a data business.
Yeah. So, would there be any rules that they would have to follow? How does anybody hold them accountable if they uh, do not get considered as data businesses in the first place?
Okay, so, I mean, I'm not sure as to, what do you mean by hold accountable? So I guess all businesses are being held accountable by different, government agencies in India. And so there is just one, maybe a doubt or something that might linger, is that all businesses, including those which are registered as data businesses and those who don't, need to share data, need to share NPD with data trustees for the relevant HVD. So smaller businesses are also expected to share relevant data to the data trustees for creating HVDs.
I mean, I'm just wondering about the scale at which this will have to happen, right? There are thousands and thousands of businesses that do collect data. How is this going to function? I mean, just in terms of the metadata directory that you're envisioning being created, the scale of that is going to be immense.
Yes, I mean, you're absolutely right there, Nikhil. So this would be an digital process, and obviously, it has to have those systems that can help businesses to easily send that information about the directories of metadata, and it will hold that. And obviously, it would also provide the capability for others to search on what kind of metadata directories are available with the different data custodians.
Okay. Aditya?
Yeah. Thanks, Darshan. So, if you could move on to Jyotsna. Jyotsna, we are aware that you looked into the report quite a bit, and so immediately, what stands out to you in terms of compliance challenges, like practically speaking, from your experience with businesses, and like what compliance challenges do you see immediately that need some amount of addressing?
Yeah, thanks, Aditya. So I think at a more general level, I know that the report has sort of concluded that there isn't really an overlap between personal data and non-personal data, and also determined when each of the respective regulations will apply. But I think that there still continues to be that inherent risk of an overlap, particularly for NPD that is based on PD, right? And as a result of which, I think what it leaves a lot of businesses confused about, and something that they need to spend time thinking about, is just the management of all of this data, right? And thinking about silos that they never had to think about in the first place. So we had personal data, which has a fairly set of extensive compliances, of course, subject to regulation, but tells you to a large extent what to do. But now you have another legislation in the works that could presumably govern all of the data that you deal with and require you to classify it and store it in a certain manner such that it remains under one of each of the regulations, right? So I think that just, at a very, very high level, people who are in charge of this data, making these decisions, there's just a lot more for them to do. Forget the compliances, because you will, of course, only be able to identify the compliances once you know which of the regulations apply, right? So I think that there is going to be some sort of thought process which is fairly intensive in terms of how to classify this data, where to store it, how to store it. And one example is, of course, this whole point on mixed data sets, right? So the report does say that if it is inextricably linked to PD, then it will be classified as PD, right? But to my mind, and there's no guidelines right now in the report of what that would mean. It does refer to the GDPR, but the GDPR also doesn't define it. And so there is an EU guidance paper that says that something will be inextricably linked if it is technically infeasible or economically infeasible or just simply impossible to separate the PD from the NPD, right? And to my mind, I think this is still a fairly subjective determination. And I'm not saying that everybody will do it, but given the general sort of sentiment towards this mandatory sharing, although it is now limited in remit and only for public good and so on and so forth, it could serve as sort of a disincentive to anonymize the data in the first place, right? And to ensure that those personal data elements are retained so that you can be then subject to all of the compliances under the PDP bill, but be saved from the mandatory sharing that we're talking about under the NPD legislation. So I think that, just in terms of classification and even this whole, the talk about localization, because for NPD, it is going to inherit the sensitivity of the PD, right? That comprises that NPD data set. So again, there's that whole question of where you actually need to store this data. Does it have to be a copy? Does it have to only be stored in India? So I think generally in terms of data management, storage, and classification practices, there is going to be a lot of work that's involved.
Jyotsna, just taking direct B2B out of this data sharing approach help? Like, are there any loopholes that you can foresee?
Yeah, so I think that while on the face of it, they've made it clear that private sharing is out of this because it is subject to contract. What this proposed legislation, to my mind, does is enable that sort of mandatory sharing outside of contract. So I know that it's limited to public good, but we've all sort of acknowledged that that is vague. We don't exactly know what would amount to public good. And then you have two instances. You have one, data trustees who can request this data from you on the grounds of public good. I know that the requests have to be granular, they have to be specific, but at the same time, and right now there are no guidelines on the proximity of the actual purpose of that HVD as well as the extent of data that's required, right? So you could then end up actually having some sort of a broad request still, right? And having to share this data. So on the one hand, while this was data that otherwise organizations couldn't have access to unless you have contractually submitted to share that data, this sort of enables either in the form of a trustee, which we'll come to, when we talk about the independence of data trustees, as well as people who can access HVDs once they're created. Because once an HVD is created, it can be accessed by private companies as well, right? And of course, it should be for public good, but there are several non-apparent uses that you can put it to, which may not be for public good, and there's literally no way to check that. This goes to the point on end use.
Jyotsna, let me be more specific. Let's say if I'm a company and you're advising me, and I wanted to take some of Panduranga's Swiggy data away, what would you advise me to do here? How should I go about doing it?
So I think it depends. I mean, if it was something like that, you're saying that you would want access to
I want that data. He doesn't want to give it to me.
Okay. Yeah, I think you should tackle problems on obesity, diabetes, healthcare, and call that your public good. Ensure that and set up a proxy in some way or the other. You can set up a Section 8, you can set up a trust, you can set up a society. Find a way for them to convince the NPDA that this is actually a legitimate public good, and therefore that you have to create a high-value data set for that and get access to that data. And I know that is going to be aggregated, but even then, that is of a lot of value.
But is there no limitation on me in terms of once I get access to that data in the Section 8, how I can use it? Like, is there, well, to give you an example, what happened with Cambridge Analytica, right? Facebook gave data to a researcher and the researcher then subsequently sold it. Is there any restriction on me selling it?
So there isn't. I'm sure that this will be solved for in the legislation. And of course, the only reason why you ought to be accessing that data set in the first place is for the public good. But like I mentioned, there are several non-apparent uses that you can put it to. And I know they're talking about a policy switch and all of that, but you still get access to this host of information that you could, predominantly and apparently use for public good, and therefore create perhaps something that puts out literature on health concerns in relation to gluten-free foods or whatever, right? So, but at the same time, you could also use it in your commercial decision-making. And you would have never had access to this data unless Swiggy had contractually agreed to give it to you earlier, right?
Yeah.
But now, on account of the mandatory sharing in the pretext of public good, you could do this. But see, I'm saying, I mean, Nikhil, there's really no way to entirely weed this out. People are going to find a way to game the system, right? But if you at least serve some sort of, to serve as deterrence, if the legislation could have some form of audits or end-use restrictions, penalties and the like, to at least limit or maybe make organizations think about what they do with this data once they get it, that could be one option, but I don't think that there's a way to, it's an inherent risk of sharing, in my opinion.
Okay, so there is a significant risk in that sense, and the checks and balances are not quite in place for usage of data post acquisition. Then,
yes.
Okay, do you have any privacy concerns?
Yeah, I mean, I think that it's not that just because it's NPD, the privacy concerns go away, because the report acknowledges that NPD could be of two types, and one subset of NPD is NPD that was PD, right? And the risks of re-identification or anonymization and the techniques that are involved could very easily result in that category of information becoming personal to begin with, right? So I definitely think that just because you apply a level of anonymization or you call it NPD under this legislation doesn't take away those privacy risks that exist. And that's why I know that we were discussing this informally. I don't think that this is as ring-fenced from privacy litigation as well.
Okay. Prasanto, any concerns that you have regarding the framing of this report?
Well, I have lots actually. Should I just quickly run through them? I'll try to skip the stuff that has been spoken about. Sovereign purpose. I think the previous one also you discussed it, and that is of concern.
We can always talk more about sovereign purpose, Prasanto. There's no problem.
Right. Okay. Then the anonymization part. Oh, well, okay. The sovereign purpose. I think the only thing was I would like to know, how transparent the thinking behind what all constitutes sovereign purpose and how that data will be protected. Could it get, for example, inadvertently shared with a Section 8 company that is backed by the government? Hypothetical scenario, that sort of thing. Jumping on to several other things. So clearly on the regulatory burden, the compliance burden, and that is a significant concern. Again, looking at it from some of the critical infrastructure areas, let's take fintech itself, there's already significant regulatory burden. There's a significant amount of data sharing, both personal and non-personal. For example, the RBI wants very, very detailed periodic reports, which are very frequent now, from all payment service providers and TPAPs and so on. Okay, now this is another one. Can it actually be handled through that regulator? Because there'll be a potential issue there. Also, this regulator, there is a potential conflict of the goals of this unlocking economic value versus protecting, consumer rights, privacy to an extent. But even if you look at the PDP regulator protecting privacy and this one protecting or unlocking economic value, then you have a potential conflict between these two regulators that we'll be dealing with sooner or later. The third one, anonymization, that's a very significant issue, and that I think has been pointed out by industry repeatedly, and I'm surprised that that has not been tackled. That anonymization seems to be actively discouraged, with consent being demanded for non-personal data, for anonymizing personal data into non-personal data. And an opt-out also being allowed. Now, for example, if I'm a fintech,
Prasanto, that anonymization is an option that customers can choose for, right? And one thing that we've established is that it effectively disincentivizes anonymization potentially. But how does this work from a company's perspective?
Yeah, so exactly. So the point is that if it's a fintech, and I have primary data, which is of course is personal. It's got content, it's got data, it's got transactions, it's got metadata, all of that. And now I want to use it for analytics, for example, improving security, looking at patterns of frauds, etc. I don't necessarily need the PII, so I would prefer to anonymize it to reduce my exposure, my risk, and all of that. Maybe I use a third party to actually process that and give me analytics on that. There's no way I would want to share personal information, but this puts an additional barrier for me because I now require consent. And this actually makes the data which I'm storing more secure. And why should there be a barrier for that? Okay, so this, and then there is the post facto opt-out problem. In case that happens, how is that to be handled? I'm not sure if this is addressing it or. Okay, so clearly for analytic, for a whole lot of reasons, companies would prefer to actually anonymize data that they're processing, especially if they're giving it out to third parties or for any other processing. And there, of course, I mean, the responsibility is totally, it remains totally theirs. The location issues is a problem. I think that's been brought up a couple of times, both in the previous conversation and this. The lack of clarity with respect to storage, non-personal data derived from critical sensitive personal data not yet defined. So there's ambiguity about the storage restrictions on that. The other thing is that it talks about providing a list of all locations of storage data and processing. That is extremely problematic. This is going beyond what, let's say, the RBI said in April of 2018 that all data must be localized, all financial data, etc. So there is, and then they said that okay, if it's processed outside, it must be brought back in 24 hours or T+1, T+2, whatever. There it's not asking you to list where all you're processing and so on. I mean, this is a very we work in a very distributed processing world today, and some of that information could be sensitive. Some of that information, I mean, it's simply not something that you're required to know. It's there should be simply the question of whether it is on soil or it is offshore. Okay, if you have to list that set of things, even in terms of storage, your backup locations, that is sensitive information. And I would, I'd be really worried about, especially fintechs and maybe any of the other 5 critical infrastructure areas that have been defined by the NCSC. Yeah, Nikhil, go ahead.
At present, is anonymized information allowed, payments related anonymized information allowed to go beyond the borders, or that is also not allowed? Like when the RBI said you must localize payments data, is that only with reference to personal data, or is it also with reference to non-personal data?
Yeah, it's with reference to personal data.
So it still contributes to the global like fraud detecting algorithms, right?
Yes, but not live. So that there's a problem there. That's a different issue. But right now, because of the RBI localization restriction, it's not live. It is it's a data set which is derived, and then it is added to the global data sets for fraud and phishing, and so that is an issue which delays, let's say, India's ability to get the latest fraud score analytics behind a particular type of maybe phishing activity which is being globally added to the system. So that's the situation there. Having said that, I am finding increasingly a tendency among PSUs, government entities, etc., to ask for location related information, or government departments which are saying, okay, if there's processing of our website in some way, even if this processing can be easily be done externally, we need an on-premise solution because there may be data legislation in the works, or we may require to have the output data of that on soil. So this is this in several areas, partly related to security audits and so on. Now, the point is, I'm talking about not audits which require an intrusive or, even a permissions-based thing where you have an, on server or on-premise software. It may be a completely external audit by an expert. It may be, something being seen from the US. But increasingly, there seems to be a requirement to look at that on-premise. So that is seems to be aligning with this direction of everything being possibly looked at locally at local storage. Okay. The metadata directory, I think that's interesting.
Could we come to the metadata directory a little later?
Okay. Okay.
Thanks. Richa, hi. As a payments company, what are your views on this particular framework? How do you think you'll be? How do you see consent management playing a role in this? How do you view the consent mechanism put in?
Sure. Hi, good afternoon, everyone. So first of all, I'll just spend 1 minute or half a minute to just summarize the report, and then I'll share my perspective from the fintech and the payment aggregation company. So definitely some of the welcome steps that we are seeing in this revised version of the report as compared to its previous version, namely first is the, in terms of the interface between the PDP bill and the NPD framework. It has essentially elaborated the concept of anonymized data. The second is clarity on data trustee, the roles and responsibilities. I'm not going to talk in detail because we have spoken about it quite in detail here in the webinar. Then, of course, the sharing of the proprietary data, sharing for the economic purposes, sovereign purposes. Now, if the very question that you asked me, by the sheer nature of business that we are in, the payment aggregation, we purely operate in B2B business space. So our main submission is that we should, since we are not the entity which seek consent directly, as we sit in the middle layer, payment aggregation, they operate in a controlled and regulated environment. And we are also subject to various certifications like PCI DSS, ISO, and then there's several RBI regulations also which are mandatory to carry on our business. So such regulations and standards ensure that the data that is processed by payment aggregation is secure and is also as per the regulatory requirements. And for an entity, no, I'm just coming to your point. So for an entity like ours, it's not really, we don't seek consent directly from the data principal, and as we are not directly exposed to the customers. So this framework, we should be like exempted from this non-personal data framework.
That was my question, that are you under the current approach to payment processors, are you exempt from the framework?
Oh, which one?
That's mentioned in the report. Are you currently exempt under this new framework?
I don't know. That is a clarity I would want to seek from the, when we are doing our submission, because currently we are in the process of seeking a license for PAPG, payment aggregation payment gateway, by RBI. But where we fit in this report, whether we are data processor, because that is the closest of what I can see of us. And as per the report, data processors will not be seeking consent directly. And so I'm assuming we would be exempted from sharing the data.
Okay, because you are also still the entity that collects the consent for a transaction, right? Through the
We don't.
Okay.
Merchant does it.
Okay. Any challenges that you see regarding compliances?
So I would say the challenges from compliance perspective is that in the report they talk about the NPD entity, they talk about, and then we already have the data protection authority, and the report also talks about over and above the sectoral regulators will also have a play in terms of deciding the regulations over top of that. So that is a concern, and it is not really clear, So I would just take an example, like we just had this data breach recently, let me not name it. So the kind of data that was leaked, suppose that is to happen once this regulation comes into place. So who would be the authority one would report to, whether it is DPA or NDPA or the sectoral regulators or to all of them? So that kind of a clarity we are seeking. It definitely imposes a lot of compliance burdens on the entity which would be covered under this NPD. So for us, we are still trying to figure out how it impacts us directly.
Okay. Jyotsna, would a payment gateway be covered under this? Would they be treated as a processing entity, do you think?
I would think so, because I find it hard, even if they're not dealing with the customers directly or collecting that information, that's only one part of NPD. But the other part, which is all of your other business data, does seem to still fall within the broader definition of non-personal data.
Well, effectively, gateways do have information about transactions taking place, and they also do. I mean, correct me if I'm wrong, but many of the payment gateways actually store credit card information on customers as well. I mean, they are complying with PCI DSS, but they do have data in that sense.
Yeah.
So as per, sorry, Jyotsna, please go on.
No, please go ahead. I think I answered, Nikhil. I think that it would still, you would still be.
So, that is Nikhil, what you just mentioned, storing of card credentials by payment aggregators.
Yeah.
Currently, they are doing it, but as and when they become the licensed payment aggregator, as per the current regulation of RBI, they will not be in a position to store card credentials except for payment tracking purposes. So that will not be kind of storing as such, which is again one of the requirement that we are seeking from the regulators. So at the moment, I'm saying the position is not clear. So I'm not really able to give you the precise answer.
Understood. Dayasindu, did you just wanted to check if payment gateways came up for discussion during the committee deliberations on processors and how they viewed?
Yeah, so I'm not sure about whether specifically payment regulators came in discussion at the committee meetings, but definitely the other processors. I mean, the ITES companies and IT companies that seem to process a lot of data of their clients. Those were clearly, being able to be identified as data processors rather than data custodians. So this is an interesting case, and it will be good for the committee to look at this case as well. So.
But Nikhil, just to add, even as a processor, of course, you're exempt from sharing obligations with respect to HVDs, but then you still have you're still a data business and you still have to share metadata, right? I mean, sorry, share information to the metadata directory.
Yeah, but if I can take this, the data processors need to share metadata about not about what they are processing on behalf of a client, but metadata, about what they do in terms of collecting data as part of their, business here.
Yeah.
I mean, for example, a data processor might be engaging cabs that traverse the city, right? So they might have data about, how long their cabs take to reach from their office to a certain location where, a few employees live. So that might be a data which can be part of HVD.
Right. I think, yeah, sure. But I think all I was just trying to say is even if you're a processor, it's not that you're entirely exempt from this proposed legislation.
Okay. One sec. So just in terms of mixed data sets, how do you think that is going to be dealt with, Prasanto?
So I haven't really considered that very closely. So I don't know.
Okay. Jyotsna?
Sure. So I think what the report does clarify is that if there is a mixed data set that is inextricably linked to personal data, it will be treated as personal data. So it does clarify that. But I think as a result, and I briefly touched upon this earlier, I don't know whether it gives rise to a convenience of sorts for organizations to decide the manner in which you want to store your data sets. Do you want to store it in a mixed fashion? Do you want to create silos just so that you can determine what the regulatory requirements will be that will be applicable to you? So, and as far as, what is inextricably linked, you have to show that it is technically infeasible for you to sever the personal data from the personal data, or you have to show that it is economically infeasible, which I think is a very subjective determination, right? But in any event, if you do demonstrate all of that, your data set will be linked to PD and therefore outside the purview of the NPD and consequently not be subject to any of the sharing requirements.
Okay. Prasanto, how do you think this is going to affect startups?
Are you talking about mixed data sets or overall NPD?
Mixed data sets specifically.
Well, mixed data sets, I mean, it's pretty clear if there's PII in that it is subject to the PDP and okay, unless it is anonymized, in which case the anonymization issues come in, which is a separate set of issues. So is there a specific thing you have in mind?
I'm just curious about the capacity of startups to actually also, of especially smaller startups, to actually create those distinctions or maintain, like the it's not the first thing someone thinks about, right? When you're rolling out a business.
Yeah. So for startups, I think that's where I was asking you, because the overall compliance burden in terms of looking at both the PDP and the data sharing which may be required is going to be very significant. And for smaller startups, they'd probably want to look at the plus side of the inward sharing that they can potentially access. But I think as you grow beyond a certain level, or even at the small level, if under every threshold they are expected to share, then that is a compliance burden which is significant. And that's something, I mean, the exact parallel I would give is of GST. I mean, it put a very significant burden on every startup and every small entity to invest in technology and, to do a set of things, including, hire CAs and so on, which they didn't. And I think you will see the same thing here.
So is there also, are there any technological challenges here for businesses in terms of, let's say, creating APIs to provide to connect with the metadata directory, and also for the transfer of data if it is requested?
It is, of course, you would need to look at automated channels, and APIs would be the way to go. And that is potentially a significant investment. I am guessing that would be a whole new industry which would come up, because lots of entities every single entity would potentially need to do that. And with the metadata part is kind of complex. So if you want to go there, I think that's a separate discussion. That adds a layer of complexity. But I'm saying overall, the compliance burden for startups is something that they just haven't thought about. The startups haven't thought about.
Okay, Aditya.
Yeah. So, like coming to the access about metadata, Jyotsna, if you could, do you see any chances of potential misuse of of metadata due to the open access nature of it? Do you think the open access leaves anything at risk?
I mean, I think it's no different from the risks that any data that is exposed and available to the public would have. So in that sense, not specific to metadata, but the one thing that I did notice is, while the report suggests that what you ultimately have to share or put into the directory is actually just the fields of metadata and therefore information about the metadata. To my mind, I would think that even just these fields and what a company, the fields that a company decides on as the basis of information that they want to collect is in and of itself quite valuable, right? So there is a certain competitive advantage that you might gain in making the decision about the different fields that you want to collect. And by having that now subject to a directory of sorts, I don't know if it's going to be put to misuse. I won't call it misuse, but it's certainly information that you may not want to part with, which you now have to part with, and can be used by organizations for various things.
Sorry, please go ahead, Prasanto.
Yeah, so I just wanted to add to that. So clearly, the metadata thing adds a degree of complexity, which which brings up a lot of issues. So I think one example was discussed. Nikhil brought up the food preferences thing, and clearly there's harms which are possible there. If you're able to identify, where. So just as an example, I mean, metadata as such, and I understand this is metadata, so it is maybe a second order derivative, as it were. But if you look at the whole central monitoring service, which basically took live metadata. Now, metadata is exceptionally valuable, and you can do all kinds of analytics on that, including, for example, which part of Delhi there are more calls to, let's say, another part of India, or to Pakistan, for example, where more phone calls are originating. Similarly, you had food preferences, which area is consuming beef, which area is consuming pork. But there is a potential interesting element, which is that certain large platforms have access to a great deal of metadata which they can really leverage. And I think the example which has been often brought up is a platform like, say, Amazon, which is able to see what kind of products are selling, and is often able to then build its own Amazon Solimo or Amazon Basics product, etc., based on that. Now, if you're saying that, okay, that kind of data, if you can define what that kind of metadata is, which is obviously de-anonymized, it's not metadata relating to individual transactions, but it's aggregated metadata, which type of wall clocks are actually selling the best, which type of products are selling the best, and make that available. That is potentially a good thing, but with caveats.
Dayasindu, would you like to react to the concerns that businesses would essentially have to give up data that they don't really want to, and so yeah.
So just one thing that I like to remind all of us is that the context of data sharing is for public good, and that's the basis for collecting these high value data sets. I mean, for example, I think getting a laundry list of whatever a company is trying to sell. I'm not sure where it will fit in with the with a public good and hence a high value data set perspective. I can understand one might want to know high calorific foods which have a direct relation to public health and stuff like that, but other consumer goods, sale of consumer goods, I'm not really clear as to how it falls into the public good objective under which the entire data sharing needs to happen. So I think it's good for all of us to keep that in mind.
Okay, so I guess a question for you, Jyotsna, because a lot of this discussion and probably the utility of the NPT framework itself depends on the definition of public good. So what do you think about the definition of public good? Do you think it needs to be a little well defined? What are your general thoughts on that?
Yeah, so in this context, I think it needs to be well defined. So I completely appreciate that something like public good or public purpose ought to be vague and broad because you want it to evolve with the changing needs of the community and the several considerations and all of that. But given that here, public good is the ground on which you will need to mandatorily share data, I think at the very least, it should not be as broad and as exhaustive and left to anybody's guess, which I think it is right now. And I don't know if this is the best way to go about it, but I was just thinking about perhaps at least for the purposes of this legislation and therefore the grounds of sharing, if we could try and venture more specific grounds that would constitute public good. And this may not be the best of examples, but I was just thinking about reasonable purposes that are mentioned under the PDP bill, right? So this is, of course, the grounds on which you don't need consent to process data. And those are a little bit more specific, in my opinion. For instance, credit scoring is actually called out as a function, or recovery of debt, or mergers and acquisitions. Or if it is a function, entire function that they want to cover, they talk about operation of search engines. I don't know if it is possible to do something similar for public good, but at the very least, if we don't leave it as open-ended, and even the examples of or the grounds on which high-value data sets can be created, this whole thing where you have and others is just sort of disconcerting to people who simply don't know or want to be able to evaluate what sort of data is going to be subject to mandatory sharing. So I think that we are in a difficult place because you shouldn't be limiting this definition, but at the same time, leaving it as open-ended as it is now is I think a bit worrisome.
Okay, Dayasindu, would you? Sorry, please, Nikhil, go ahead.
Sorry, but go ahead, Aditya. I have some questions on competition, but go ahead with yours.
So yeah, Dayasindu, so if you could react to Jyotsna's comments on the public good definition rather being a little overbroad, do you think what was the idea behind that definition in the first place?
No, I think Jyotsna herself, placed the argument very well. So it is a difficult balance between making it broad so that you want to include as many public good purposes, and at the same time, define certain, certain examples of public good. So I think this will have to evolve as we go down this path, and there would be newer domains of public good which emerges, and that needs to be pulled in, and there might be certain cases where public goods definition is broad, as she said, and might be amenable to gaming the system, and so we need to work through this as we move down the path. So there's no single right or wrong answer here.
Okay. Thanks, Dayasindu. I was just wondering about how would the committee, from a competition perspective, resolve the proxy data trustee issue, that someone can, as a proxy, go and set up a high-value database and then use that to make data available to businesses that might want it. And also, in that sense, what kind of what is the obligation of a high value database, of a trustee of a high value database to share that data with everyone who wants it, right? They can also be selective, can't they? Isn't that a risk?
I guess it's for me, right?
Yeah.
Okay, so that's a good one, Nikhil. So as in all institutional models, I think there would be externalities, negative externalities, and we obviously need to go down the path to figure out how we can mitigate some of these negative externalities. But I think the report gives us some pointers as to how this would be dealt with. I mean, essentially, we are saying that there could be a data trustee who wants to game the system and be a proxy for another commercial player. So the NPDA has been given the objective or the goals to ensure that the HVD is appropriate for a public good objective, and the NPDA will also assess whether the community is represented well and by the data trustee, and the data trustee has the kind of credentials that a data trustee should have. So even in terms of the actual data sharing mechanism, so I think the committee has said that there shouldn't be any harm that is caused to either the data collector or the data source, and there won't be any proprietary business information that would be shared as part of the HVD. I think that's also pretty clear. And there is also an interesting clause which says that the data trustees cannot be non-discriminatory.
There is proprietary information in the analytics that a company collects, right? That can be of a value to another company or value to a community. So I'm not sure that the data fiduciary or the data collector won't be giving proprietary information.
Yeah, I mean, so we are just, I think what we are, having as a model of data sharing is, data which the data collector has collected from the, from India, from Indians, from the community.
Yeah.
So there's no, I don't think the data sharing mechanism here talks about, the need for a data collector to share, analyzed information.
But that is under that does get covered under the definition of non-personal data.
Yes, but then there is a very clear table on,
and it could be in public interest.
So, so I think there is a table which says that what kind of data, is to be shared. It is parts of raw data, it is aggregate data, and inferred data doesn't come under that category of the data that needs to be shared. So there is a table which is in the report which states this, and the other thing, which I was mentioning was that the non-discriminatory nature of data that needs to be collected by the data trustees. I mean, obviously, you cannot just go to, if you have three major companies collecting a kind of data that you want for the HVD, obviously, you just cannot go to two of them and say that, hey, give me the data, and then go easy on the third company. So you would have to collect data in a non-discriminatory fashion from all the three, who are the major collectors of such kind of data.
I actually meant, when I was talking about, I meant giving data to someone. They can be discriminatory in that action, right? There's nothing that prevents them from choosing to give data to one versus to the other.
So so here I think the data trustee is expected to share data with any Indian registered entity. So I don't think they can pick and choose on who they want to share the data with. I mean, the data trustees cannot pick and choose who they want to share data with. And finally, the community. And finally, the community has, the ability to question the data trustee and complain against the data trustee if the community feels that the data trustee is not representing their interests as they should.
Okay. Thanks. I think Rahul Sharma had a question. Rahul?
So, sorry, I just wanted to add one point that in this, it is, I mean, in the public good and the competitive issue, I mean, if the data can be shared with a Section 8 company, which is actually a direct competitor of the entities in that sector. And, there's a line somewhere which says to provide better services. So that is of concern. There's already a fair bit of, and if it's a Section 8 company, again, backed by the government. So there is a fair bit of concern about this set of clauses which enables this.
Thanks, Prasanto. Rahul, you had a question? Rahul, you're unmuted.
Muted, you mean?
No, he's unmuted actually. Okay,
Oh.
Let me ask that anyway. Rahul's question was for you, Prasanto. That what are the sensitivities for companies to disclose location and jurisdiction for processing data?
So the sensitivities, so first of all, there are fairly complex, if you look at global payments platforms, for example, they're very complex systems which are used at different parts of the payment thing in giving you, let's say, a fraud score, which comes back in 0.3 seconds to give an okay or not okay on the payment. There's fraud analytics, which is going in, which could be in third parties. Okay, there may be contractual non-disclosure agreements on both sides that they are not disclosed. As far as the location is concerned, you may have extremely sensitive data which you're using a second backup location, which may not be as well physically secured and protected because it is anonymous as your primary server locations. So there's a number of reasons why you would not ordinarily disclose all the locations involved in a fairly complex global platform, which is processing a set of things like a consumer payments. I'm happy to share more on this. There is stuff on this available.
Actually, Richa, would you like to react to what Prasanto is saying regarding the sharing of data? And probably after that, if Panduranga could also comment.
No, so I had a very generalistic view on this. When we talk about sharing the location of the servers that you asked me for, so purely from the regulations perspective of what I have seen in the industry that I have been part of, when the regulators say that there is a data localization in place, so that means you have to comply to the law of the land and all your servers should be based out of India. So even if you don't share it with the regulators or with the authority, it's a common knowledge. So I don't see any concern if you have to share the location of the servers. That is
No,
my
yeah. So the question is it just country? Is it on soil and offshore? Because that is the current level of information that is required by RBI, and that's the current constraint. But location is very specific. If you have to share locations,
yeah.
that is what I'm concerned about, not whether it is on soil or offshore.
I know, but usually, whenever we are having the conversations with the regulator offline, online, everybody shares the location of the server as well, apart from onshore and offshore.
Not global payments companies.
Okay, Panduranga, what do you think about this discussion? Is this something of is this a consideration for you from your perspective?
No, I haven't thought through this, and most importantly, this is not a case where I have to really worry about. So I haven't really not thought through this. But I think a broader understanding of the location details should be all right. I don't know how it has been looked at from the regulator perspective.
So Aditya, I was just thinking about this requirement comes in for data businesses, right? When they register, or these are part of the disclosure requirement. So I mean, of course, I know that there are people who have been assisting the committee or on the committee on this, but perhaps it is actually just offshore, onshore, and not more than that. Because I don't really know, and maybe I don't, maybe I'm not the right person to be saying it as a lawyer, but I don't really know what the value is by knowing the location of the servers as opposed to knowing whether or not you can access that data. So maybe we're sort of reading into it too much, but if it is a disclosure requirement for a data business, I would think it should just be, are you storing it here? Are you storing it overseas? And that's it. And sometimes you don't even know where actually data is stored, right? Where the actual location is. It's not really traceable.
So that's into what was exactly I mean, what was the thought process behind this provision in the first place? If you could what was the committee thinking about that?
I mean, so as I said earlier, I mean, I was just helping the committee to prepare the report, so I'm not speaking on behalf of the committee here. So I think the report says that it is a disclosure requirement on where you are processing the data. So I think we should, go with what the report says.
Yeah, Thanks. Dayasin. So we actually have one question from in the Q&A. This is from Aditi. Maybe Jyotsna, if you could take a shot at it. So basically, she asked that how will this regulation work alongside other laws? For instance, the labor codes. The new Social Security Code has a provision where it allows governments to ask aggregators slash platforms for worker registration data, which they want monthly or at short intervals. How does the idea of community in this law work with these provisions? I guess this would perhaps mean that the community is the workers themselves or a workers union. But if you could probably like elucidate it a little bit more.
Yeah, sure. I mean, I've not actually extensively studied the new code, the labor code, but I would think that in that sense, as far as sharing is concerned and sharing with the regulator is concerned, that shouldn't, ideally be conflicted with this law, right? Because you anyway have your several disclosure requirements that are applicable to your sectors or as a part of your compliances, which will continue to exist, right? All of the disclosures, the filings, the reportings that you make. But here we're talking about sharing of this data beyond just a regulatory compliance requirement, but for a specific, or not a specific, but for public good, right? And so I don't see them being in conflict with one another, but I haven't actually really gone through the requirements under the code to see if any of those specifically will impact the sharing that's contemplated here.
So can I come in here, Aditya?
Sure, please.
This social security code requirement is that these platform workers, gig workers have to register themselves for the social security benefits. So that will be a 10 or 13 digit number, location of number, which requires some registration. I think now we need to compare that with the existing social security benefit for the employees. There is a PF Provident Fund that also have a similar mechanism. So we shouldn't be like mixing this with the non-data protection laws. So this is different and completely for the regulatory purpose. And
no, I guess the question that the Aditi had perhaps was more about the fact that there are government that the government can actually ask data from the from aggregators, and how would that be defined? So I guess there is that would be perhaps anonymized, and that would perhaps come under the NPD framework. So.
Yeah, but I think the point that I was trying to make is that this is going to be horizontal. And when I say this, I mean the NPD legislation is going to be horizontal and not an agnostic to specific requirements under existing laws. So if the question is, are they going to conflict with each other? How does one go about responding to those requests? I think that they will still be under different processes that would not conflict with each other.
Okay, I guess there was one more question I think we have not addressed. So this was for Prashanto. So I mean the NPD report actually clearly states that it wants to unlock the economic benefit of this data, but at the same time, do you see if there is a conflict of interest with the privacy angle? So do you see a conflict with those roles, and if you could tell what you think about that?
Yeah, I totally see a potential conflict of, and I did mention that these are often two different things. And if you have a regulator which is supposed to, or even if you have two regulators who are aligned, the DPA and the NPD authority, so there will clearly be a conflict in situations where, if you look at the bulk of data being collected and the derived and the value of the derived data, and again the food example is one thing where there will be sensitivities about the kind of food being consumed or the type of phone calls which are made, which is based on metadata. So even if you take metadata of metadata, so I would be concerned about my privacy, even though it is not my individual personal data which is actually being. So there are potential harms which are derived from there. Okay. Now the economic value of that could be a case which is made, and that economic value might trump the second order harms which is apparently there. So there's clearly a conflict there, and I think given time one can think of other examples beyond the food or the telephone calls or the other examples.
No, I was just thinking about the scale of this, I think somewhere it was said that Facebook collects some 15,000 types of data points about each individual or something like that. I don't remember the exact number. And I'm wondering that for all the businesses here, as well as you, Prasanto, do you think that it's technically feasible, or you think that this, I mean, what is going to be the impact on businesses if they have to share that volume of of metadata about metadata with the metadata directory? And this committee hasn't really gone into the, like, at what frequency do they have to keep that metadata about metadata updated. A lot of this metadata is generated using algorithms, which means that it's generated on the fly. How does that metadata directory portion seems to be extremely complicated and cumbersome, at least from a non-technical person's standpoint. Is it feasible?
Yeah, so it's enormously complicated now. I would say that large organizations who deal with enormous volumes of data would be able to put that in place, and equally would want to restrict that as much as possible. And, I think the Amazon or Flipkart example, I did refer to that, because that's extremely sensitive. That metadata information is, it's competitive. It gives them a competitive edge about what kind of products are selling, with what kind of changes in price, what kind of algorithms are working best when you put a price change for a person who is shopping at midnight versus etc. All of that. So that is data that I would imagine large platforms would want to try and protect. Beyond the complexity, there is that question. For smaller entities, for startups and so on, the complexity will be daunting. And that's where I said, I mean, if they have found GST complex, they haven't seen anything yet with data sharing requirements of NPD.
Panduranga, any views on this?
Sorry, could you please repeat the question?
So I'm just saying that if you think about the amount, like the requirement is for a metadata directory to share to have metadata on metadata. And I'm just curious, like, what is the scale of metadata that is generated in organizations such as yours? I mean, from what I remember, Facebook collects some 15,000 data points on each individual, and a lot of the data points are, and you would be collecting that on both your delivery personnel as well as on customers. So how complex is this task of having to share metadata about metadata mandatorily with the non-personal data authority?
See, this metadata are not always accurate. And I'm just giving you some disclaimer before I say something about it.
Yeah.
Right. And I'm not speaking for like what Swiggy does. I mean, generally, I can I can share my understanding of how this metadata collected.
All caveats applicable here.
Yeah.
As an individual, private individual, what is
collection of metadata could be for multiple reasons. This is purely because of a certain business propositions, or maybe some of future business development point of view. And there are certain cases where they want to improvise consumer experience. These are all the reasons primarily for collecting those metadata. And now those collection of metadata need not be constant. If in a time, for example, one social media site is collecting 5,000 metadata points, not necessarily that they continue to collect 5,000 or increase more than 5,000. So it can constantly like vary between anything to anything, and therefore it is not so constant. And if assuming like this the committee were to, I'm not sure whether committee thinks that way, but committee were to ever think that way, that there could be a constant metadata requirement, or maybe the government were to like call out these are the metadata on which this data informations are required. These social sites are any data businesses might collecting metadata may not collect it only for the compliance requirement. If it is relevant for their business, they would continue to collect that. So we need to be mindful of that.
So if I can just add to that, if a company is not collecting and it does not collect because of nature of a business model, etc., and this forces them to do it, well, that's a different concern. And WhatsApp is, of course, an example. If the primary content is end-to-end encrypted, they say that they do not at all store metadata because that is a privacy concern. Signal doesn't store metadata. Now, to give metadata of metadata, you have to have metadata to start with. So that would assume that all of these intermediaries, which are messaging sites, etc., will have to start collecting metadata if they're going to give any derived metadata out of it.
I don't think that's the case, right? It's just saying if you're collecting and then you got to share it as the kind of approach they're taking. They're not saying you have to collect certain metadata and give
So
it.
that's, I'm not very clear about that. Is that the case? I mean,
So
are you excluded if you?
again, the point is that we're not sure of, like, what is this about. Collection of metadata is not very clear.
Okay. Jyotsna, do you see any competition issues arising out of this?
I think Jyotsna had to drop out, Nikhil.
Okay.
She had an urgent call.
Okay. Anyone, competition issues?
On metadata?
On this requirement of metadata. I think we have Rahul Mathan here. Rahul, we'll just upgrade you. Maybe you can address that question. Competition issues. But Prashanta, go ahead if you have any views on that.
No, I was just adding one point to the previous thing that, something like WhatsApp is, as you know, very much in the primary gun sites on the intermediary guidelines, etc. So that is something where, I mean, there'll be clearly an expectation of derived metadata and so on. Unless it explicitly says that, this will not make you generate metadata or collect metadata, which you don't primarily collect. But this will be another point of pressure on all the entities which are trying to stay encrypted.
Okay. Rahul, competition issues not in your capacity as a committee member.
Can you hear me, Nikhil?
Loud and clear.
I was not intending to be in any way, shape, or form on this. So I neither have good quality audio nor good quality video.
We can hear you well.
And I'm not a committee member. I'm less of a report preparer than Dayasindhu, so this is in all fairness should be addressed to him. But having said that, look, I think the point he mentioned, so of course, look, there are competition issues, and I think the committee, not only competition, there's intellectual property, there's information technology, and there's PDP issues in terms of conflict between all of them. And the committee, at least in this draft, seems to have very consciously tried to find a path through all of these. And I think one of the significant things to address competition is 8.8, which actually says, and I think Dayasindhu mentioned this slightly earlier, which says that you can't pick one entity and ask that entity, look, give me your data, I want to build a HVD. You have to go to all the entities in that sector. So this, how does a framework like this give rise to competition harms? It's when you misuse this framework to try and derive business information, information that's specific to a particular industry from one entity in the industry in the guise of creating a HVD. And so that's sort of one of the things that is slightly hidden away in the report, but I think is significant, which to indicate that the idea is to avoid competition harms. And of course, there's the statement up front, which says that it doesn't apply to proprietary information and trade secrets. That's a caveat right up front in the report.
If it doesn't apply to proprietary information, then what does it apply to?
No, that the idea is not to impinge upon a company's trade information through this framework.
Right. So then the question is, what does it apply to? What's left?
Why does everything a company do have to be proprietary and trade secret? I mean, we've talked about weather data, we've talked about traffic data, which is completely incidental to the business of the company. Why would that be proprietary?
In that sense, don't you think that a lot of the NPD being considered here is co-created data?
So look, it could, and I would, for every example of co-created data, I could give you an example of sole created data as well. And if it is co-created, I think the framework is not getting into the fact that it is co-created is not giving rise to a proprietary right if it is for a public good. So if you see the overarching construct of a public good, then if one person creates a public good or if 5 people create a public good. If the policy decision is for public goods to be shared in high value data sets for public interest, then however many people created it, that construct should stay true.
Understood, Rahul. I was just talking about, let's say, a company like SkyMet, which has invested in infrastructure to collect weather data, for example, and is running a business parallel to, let's say, what the Met department might be doing. And so that is valuable data, but it's also, there's an investment that goes into creating that, and that would effectively be available here. That's not pertaining to an individual, so therefore there's no privacy concerns there. But I'm just, it is, data that's in the sky, based on information that's in the sky. And so I'm just wondering whether they would claim intellectual property over that.
Yeah, look, and I know Prashant has raised this on in the context of the previous draft as well. Just this whole investment in infrastructure, which gives rise to completely non-personal data, as it's got no relation to personal to humans, and that is a challenge. And that's why I'm saying, look, I think, and it's not clear. It's certainly worth discussing in some extent as to how we're going to deal with it. But if you've built your business out of creating, collecting data, and that is sort of the core of your business, if someone strips it away from you and gives it out to the public, there's a fundamental inequity in that, which I recognize, and I think that is something that certainly we should list those examples and find ways in which we can address that.
Great. Thank you so much for joining us, Rahul. Always a pleasure debating with you and maybe challenging my own thinking.
Can I go quietly now, or are you going to drag me in without me knowing again?
I might drag you quietly without you knowing again, but I'd love to have that privilege, Rahul, as always. But thank you, everyone, for a great panel. We are bang out of time for this one. The last one is going to be on one of my favorite subjects, which is the construct of the non-personal data authority. I'd like to invite Beni Chugh and Alok Prasanna Kumar for that part of the discussion.
Hi, Nikhil. Can you hear me? Can you see me?
Yes, Alok, I can. Beni?
Hi.
Hi, Beni. Good to see you. So I'll start with you, Alok.
Sure.
What are your broad thoughts on this report?
Okay. I have 3 very broad thoughts. I will not try to take too much time on this, and forgive me if there's already been discussed. I couldn't join the earlier part of the discussion because of a prior obligation. But I think while in as much as there is value in non-personal data, I'm not entirely convinced that the state has to have a role in it or should necessarily be involved as a regulator in it yet. There may be a time when it needs to happen. I don't see the need yet, because in my reading of the report, that case has not fully been made out. I sort of specifically want to go to paragraph 3.3 and 3.4, if I can take the liberty. I'm sure you've looked through it, but I just want to go through it as well, just to sort of make my point about the authority. The concerns raised are valid. It's just that they don't necessarily lead to the conclusion that we need a non-personal data authority, or rather that we need a regulation which will necessarily help us for sovereignty, benefit India, benefit the world, privacy, simplicity, etc. I feel that the existing legal framework may at best be tweaked in a few ways to achieve exactly these outcomes without necessarily asking for one overarching authority. And I say this for 2 reasons, because the authority has not been very clearly thought out yet. I go to the section in section 7 of the report, which talks about the authority. I don't find that authority explained very well. I think there is still a gap as to what is in the report, there is a gap as to what is the problem this authority is trying to solve. You don't just set up a statutory authority because something needs to be done, so therefore this authority should do it. I don't think that is the right approach. That's the right regulatory approach. You need to have a clear idea as to why an authority, being a state entity, should involve itself or interfere in this matter. The second reason why I think that an authority is not necessarily needed is because it might lead to enormous conflicts with existing bodies, specifically such as, and I think of 3 bodies. One is the proposed Data Protection Authority under the PDP bill. Second is the Competition Commission of India. And the third is the Central Information Commission. The reason why I say so is potentially a lot of the data that we're talking about might be sitting with government agencies, and it might be possible to get some of this data, because if you see the scope of what is non-personal data, some of this is in the public domain. It can be retrieved through accessing an RTI. So we may not necessarily need a separate authority for this. Even, for instance, a private entity working for the government sitting with data, you can potentially approach it through the RTI to get access to that data. So I fundamentally do not see why we need this authority in the first place. And we can then go to the question of design and so on, because to me, all these goals are entirely valid, except one which I will nitpick about, if it sounds like nitpicky, but I didn't understand the distinction between India and its people. India is its people. India and its community, they are not two different things. There is the Indian government and the people of India. There are communities in India and there's the government of India, but India is its people. So if the people of India are to benefit from something, that is a place where you can sort of make a regulation, but you have to say what is the benefit that the people of India will get that they're not currently getting in some way. Or for that matter, or somehow that there is this is like a public good which cannot be provided by the private sector, which needs to be provided. I mean, at some point we may get to that situation, but I'm not very clear at the moment.
So Alok, it's perhaps, I think the argument that I have seen is that there is data is underutilized in terms of what it can provide, and the utility, and therefore there is a need to take this data and give it to who can utilize it for public good in order to further economic activity and the utilization of data. It's like I used the example earlier. It's like ride sharing.
Yes. Yes.
Versus you having a car parked in your house.
Correct. Except the difference is this, if we take an example of such as even under eminent domain, if you take the power of eminent domain, very few places in the world say you have to take it without compensation. Right? If eminent domain, and by eminent domain, I don't mean that you're misusing the property and therefore the government is seizing it. Government thinks there is a better use for it, but they are compensating you for that loss. If we have to approach it from that direction, it's a completely different discussion. It's not about enabling easier use and access to everyone. All right. I don't want to bring that in because it will cause confusion about property rights. It will cause confusion about what are proprietary rights and so on.
But we have to discuss both of those aspects here, right? Property rights and proprietary rights.
Yeah. So for instance, like the question which we have sort of said, and which I sort of keep saying, is don't use a property rights framework for data, because data does not fit the requirement of what in law we understand as property. In property, if I give my property to you, it ceases to be my property. I cannot use it anymore. But in data, I can still retain data and give you copies of it, right? Now, a law can say that giving this right will be protected. When you have this right from me, you will be allowed to use this under law. And that's a proprietary interest that you're getting in my property. It's not exactly for property, but there's an interest of yours. It seems like a property right that is being protected. But I'm not very clear, and at least from my reading of the two reports, it does not come very clearly to me why the state needs to intervene. Somebody recently pointed out to me that in all these events, you are the state statist. So let me take the slightly contrary view in this particular one to say that it's a positive case which needs to be made for state intervention. Some things like this may require very minute intervention. To give you an example, supposing if the Karnataka state government wants to improve traffic in Bangalore and says that Uber is sitting on this data, I don't see why we need a nationwide single regulation to address this. Karnataka government can approach Uber and say, we are willing to pay you. Or if you want to get into an MOU with us, we are happy to get into an MOU with you on anonymized traffic data so that we can plan our city better. Let the solutions be found at a local level. Let the solutions be found at a state or a subnational level. And each person may need a different set of data. You can't apply a health data framework to traffic data framework, to education data framework, to everything else. I don't see that these different kinds of data have, or even if they're not, even if they're anonymized, even if they're non-personal data, that they all need to fit the same, framework in this basis. So there may be an overarching framework on how to think about this, But law should not prescribe one framework where all of this should be done, right? That positive case I am not seeing from this, and therefore I don't see the role of an NDPA or an NPDA, a non-personal data authority, can play in this context. At best, you may want to give the Competition Commission some competence, some capacity to ensure that there is no abuse of data, which will, or rather, no holding of data which will prevent competition from others. I get that as a very valid exercise, which can be done within the Competition Commission of India. There are dangers from de-anonymizing non-personal data, which might lead to actual harms. That is something that the Data Protection Authority should concern itself under the PDP bill. Or if individual governments want access to some data for public good, they should negotiate one-on-one or find ways to get that data one-on-one with those who have the data. So I don't think that a large, wide-scale legal framework is necessary, or even at best, let me put it this way, the two documents, the earlier draft and the present draft, does not make a coherent argument as to why this is needed, and therefore I'm still struggling to find the justification for the creation of this authority.
So before we go to Benny, let me just play the devil's advocate here.
Sure.
What if Uber refuses to give that data to the Karnataka government?
Go to Ola.
What if Ola refuses?
So find a way to make a regulation. For example, Uber and Ola have to come to Karnataka government to get a license to run their taxis. Karnataka government can say, we'll give you a license only if you share non-personalized, anonymized data about transportation with us. Now,
how does this work for unlicensed entities? Let's take Swiggy.
Sure.
How will it work for them? Let's say I'm the health department and I want to make an intervention regarding consumption of fast food. I want to know which are the areas where there is a significantly high consumption of fast food taking place. I go to Swiggy, I go to Zomato, they refuse to give me that data. Now what do I do?
Sure. In that case, Swiggy and Zomato are also bound by labor regulations. They do have to provide data and details about this. The health department can go along with the labor department, and the health department can approach can go to the Karnataka government, the other departments of the Karnataka government, and say that since we are also in charge of regulating the labor aspects of the workers, I think there is a good second order benefit. The first order benefit is still that you want to ensure protection of labor. Ask for anonymized details of where, for instance, this what kind of orders are being present. Or for that matter, go to the main fast food companies which are dependent on you for certification. Fast food companies, like, if you want to take names, like say a McDonald's or a Burger King, whichever is sufficiently prevalent in Karnataka, they will necessarily have to take certification from the state government to ensure that they are maintained clean and etc. and etc. Make a requirement to say, I would like you to provide me data. You have GST data as a Karnataka government with regard to, you can get data from the GST agencies with regard to what is the billing of these various things. That is something that the government might already have. I would want the government to be creative about thinking of where we can get this data from, rather than imagining there is this big dump and we can just get whatever we want, however we want, from whomever we want, whenever we want. I don't want, in a sense that data is useful. I don't dispute that. Data will be crucial for a lot of aspects of governance. I just don't see that a large nationwide framework will fit the purpose of every single person or entity who wants to make use of data for the larger good.
Okay. Thanks, Alok. Benny, on the non-personal data authority, do you think that we need a separate non-personal data authority? And also, just in addition to that, are there any initial comments that you'd like to make on the paper?
Yeah, thanks, Nikhil. I think the last time I was here, I spoke about the same topic.
I know.
And unfortunately, my views haven't changed since. I do struggle to find the justification for the non-personal data authority a bit. I don't see a very convincing argument like Alok said. My reasons are slightly different. I first think that if you are regulating, I think that what we are regulating for is also slightly unclear. If the question or if the objective is that we're regulating because we want to privilege Indian startups over any other kinds of entity, then we need to say that upright, and we need to stop guising it in the word community, because then that gives a very different kind of perception, and think of a lot more in addition to just economic value when you think of a community. So if the idea is that you have to kind of privilege Indian startup in the ways they can access data, then I think I'm not a lawyer here, and far from an administrative lawyer here, but I do not know how this institutional setup will help them achieve that objective fairly. The reason that I say that is that there is the same set of institutions where anybody and everybody can go and ask for access rights to non-personal data, be it HVDs or any other kind of data. And then you have one data, non-personal data protection, non-personal data authority that will decide over the merits of your case should the data custodian actually deny. Now, what happens when a foreign startup, so to say, kind of finds dispute and says that actually my case is valid, I should get access to this data, but we do know that internally there is a preference for internal startups. Just from this institutional arrangement, I don't see how we will reach that premise that we want to. So that's one aspect of it, that what we're trying to kind of achieve needs to be stated out clearly, because then that will affect the entire policy choices that we make here. The second is, I don't really, I am afraid of this regulator taking shape, because I do feel that basic regulatory hygiene would call for a fixed regulatory perimeter, no matter how wide or how big it is. That's a question of state capacity, but at least I should know who I can regulate and who I cannot. Here, because identifiability is the basis of regulation, and identifiability is almost like a moving target, then the kinds of data that are within my remit, they are bound to keep changing over time. And I don't know how a regulator would contend with that. And then the third thing is, and this is probably me not kind of engaging with the document deeply, or a limitation of my imagination. What it says is that basically once you re-identify anonymized data, you fall back in the purview of the Personal Data Protection Bill. Logically, it sounds very clear and very systematic, but I don't know who out there is going to say, hey, I identified some people by mistake, I should now go to the PDP regulator and I should now follow those regulations. Like, how do we even take care that, there are no gaps and there's no regulatory arbitrage? And I think on those counts, and maybe there are people who know better, but on those counts, just the idea of a regulatory body just yet, when we don't have experience of regulating data, kind of scares me a little bit. And then, of course, there are interesting institutional design choices that are made here. I think that like it's a very interesting design, because I have yet not seen a blueprint like this, where we have such deeply entrenched intersectoral coordination, and we are assuming that we will be able to achieve that intersectoral coordination and come at regulatory decisions that are harmonious across sectors. I mean, I don't know if in India or otherwise in the world there is a practice that allows regulators to communicate that smoothly and freely, and I do feel that for this one we will need this to be a default and 24/7 type position, that all decisions are made in consultation, because like Alok said, it's going to affect a fair bit of, and others have also said that it's going to have competition implications. It's going to have many more implications, and not just, so the remit of NPD will always be shared with other regulators, but I don't know if we have a good kind of blueprint to execute that. So that's my second.
I'm just curious about how they'll separate the powers of the NPDA from the powers of the CCI.
I am so it's interesting. We were hoping that this version of the report would have some of those answers. It does acknowledge these questions, but it does not really indulge you with logic as to why the CCI would fall short. I think that, I mean, both would, CCI, the sectoral regulator, for instance, if RBI has a public credit registry where people are supposed to share data of individuals, and if the promise is that that data will be anonymized, then that's like a competing arrangement as well. When I look at that data sharing arrangement with this non-personal data sharing arrangement, so there are going to be, regulators are going to be stepping on their on each other's toes, and a clear. That's what I'm saying, that the regulatory objective is not clear. So you can't really distinguish between enforcement powers and jurisdictions of the various regulators that there are.
Okay. I mean, in terms of like, what do you think the NPDA will be unable to handle? What are the kind of situations that you see coming up that the NPDA won't know how to deal with, in a sense, at least given this particular framework as we see it?
Yeah, I mean, first up, if this is coming, then I wish it all the best. Like, I don't want to kind of drown it in my cynicism.
Just as context, I think one of the questions that we received that we didn't take in the last one was like, if there are competing demands for a high value data set, how is the NPD going to resolve that?
I think, and I'll just raise questions here. Please don't expect answers. But a few of these gray areas to my mind are, first up, even deciding who gets to be a data custodian and who gets to actually represent the community. I don't know if there is kind of a mechanism. If there are competing stakes to be a data custodian, then how does the NPDA choose which is the one that should actually get to represent the community is unclear to me. Similarly, when there is a problem, for instance, if an entity which wants data actually finds that the data custodian has not met their demand and approaches the NPDA, then I don't know how does the NPDA balance out competing claims, because on the one hand, it might not be in the best interest of the community, and that's why the belief is that's why the data custodian would not have given them the right. And on the other hand, there is this organization that is adamant on having access. I don't even know if there is anything to kind of adjudicate there. If the community have said that, no, it's not in our best interest and we're not giving it to you. If it is for communities' benefits, then why aren't they having the last word? But this is an interesting problem to my mind, that how would you actually reconcile these competing claims? And I think generally, how will I don't know where in the priorities of the NPDA, preserving consumers' kind of autonomy, decisional autonomy. We know by now that non-personal data has uses that can affect people's decisional autonomy. How do non-economic consequences of sharing data actually weigh on the NPDA's mind? I am very curious to know, how would they make those decisions? So to my mind, these are questions that this draft hasn't answered yet.
So I'm going to turn to you for answers to these questions in terms of what would you like to see. And this goes from a question that Keshav Dakar had asked in the last panel, but because it was in chat, we missed them completely. He asked about what are the safeguards for data custodians against competing communities and data trustees as to defining, requesting, and sharing high-value databases and related burdens and complexities.
Wow. Okay. I'll take a stab at it.
So therefore, first to you, and then maybe Alok can take a stab at it. What safeguards do you think should be there?
I think that before we even went into the weeds of the institutional design, what we needed were some principles. So, for instance, the duty of care principle needed to be fleshed out a bit more. That what are the parameters that you would kind of take into account when you would share data. For instance, in Australia, when authorities do share non-personal data, they have only one condition or one criteria through which they judge, which is the magnitude of the public good that is being created, right? So there has to be some criteria that even when you want to apply to get access to non-personal data, these are some mandatory checkboxes that need to be checked. Sorry for the word. But additionally, then I know that for privacy, it was a bit easier because it was located in fundamental rights. So we got the constitutional limitations of proportionality with it. But there should be some similar principle that basically takes into account, does not let, how do I put it, in an economics language, I would say that internalizes the harms when you're actually giving access to non-personal data. So it's not only the benefits that you're looking for, but even at the time you're granting access to non-personal data and you're sitting on those cases, you should actually have a principled way of saying which demands are valid and which are not. And I think that even before we went into the institutional design, that kind of a principled thinking would have been nice. A second slightly administrative law point is that we do see that data custodians can be government entities or private entities. And then the NPDA is going to be a government entity itself. And then when a data custodian who has who has a case against a private entity, and let's say the data custodian in this case is a government entity, actually approaches the NPDA, I don't know how that works out, because I don't know if the one arm distance kind of formula here works out. So these two guardrails for me are important.
Maybe the NPDA is as independent of the government as the proposed PDP authority. I'm just kidding. Alok?
I just even wonder, forget about between communities, within a community. For instance, if, for instance, let's say transport data, you want to take data of all truckers, maybe those who are transporting cows don't want to give the data. They don't want to hand over the data like that, just like that. Maybe within a community, you, as a transporter community, you may think, okay, if we hand over data of how coal, oil, etc. are moving, no one will have a problem. But those who are transporting cows may say, hey, hang on, we could just get suddenly somebody, we might find a barrier placed on the road that we are using, and we could get beaten up on the accusation of being involved in beef trade or whatever it is. I'm just saying these are very complex conflicts that shouldn't be addressed in the context of data. I just feel that this definition of community, if I have to quibble a little bit, I don't think you can translate this into law. As a theoretical framework, it might make sense, but I don't think it can be translated into law, because there is no real way for a community to speak. Now, if I can just take a slightly different example from a slightly different context. Under the Constitution of India, all rights are generally individual unless they are rights of a group of people, right? But they're identified groups of people. Linguistic minorities. Linguistic minorities have right to set up educational institutions. Religious minorities have right to set up and manage their own, temples and mosques and so on. So it is clearly defined. There is something which guides what community. So, for instance, you can't form. You can't say that anybody who is people of like mind can form a school and they enjoy the same protections as a linguistic minority, right? There's a clearly defined boundary to what is the community, and there's a clearly defined boundary to what is the right. So linguistic minority does not enjoy like a right to a reservation, quote unquote. They enjoy a right to run their own institutions. Here, that those kinds of boundaries are not drawn. If I have to read the committee defines a community, and again, as a theoretical construct, it makes sense, as any group of people that are bound by common interests and purposes and involved in social and or economic interactions. It could be a geographic community, a community by life, livelihood, economic interactions, or other social interests and objectives, and or an entirely virtual community. To me, it's like saying, we can test how sweet each fruit is from a basket. I don't think you can, just because they're all quote unquote fruits, you're literally comparing apples and oranges. To me, they'll all fall within the definition of fruits. Biologically, it will fall definition of fruits. But if you want to compare how, if you want to compare the taste of an apple to a taste of an orange, you're literally comparing apples and oranges. To me, this definition is too broad, and the kinds of conflicts that you have highlighted are impossible to resolve. You will never be able to come up with a set of principles which will apply across the board to say, when you have this kind of conflict between communities, within communities, how should the data custodian address these? It's not possible. You cannot come up with a set simply because this has been defined too broadly. I don't think it can be translated into law to say this is who a community is. You need a more precise definition. You need
How would you resolve it, Alok? How would you, let's be constructive. How would you resolve it?
Sure. I would sort of resolve it by first starting with a more limited definition of a community. And community, by which, I mean, this is a hazard, and this is not something I've put very much deep thought into, but in the context of this, community should not just be what they do, but what their data does. So, for instance, people, for instance, whose car data has been collected, they might form a community. Not everyone who owns a car, or everyone who uses roads, they might also form a community. But for the purpose of something like this, people who use a car, I mean, it's a rough example, but bear with me for a moment, might be collected as a community. People whose children are studying in schools, because students themselves cannot give their data out like that, their data, they would form a community. So if it has been collected by the education department based on the fact that you've gone to students, I think the gaze should switch, where groups of people whose data has been collected for a specific purpose and who share certain common attributes. You have to sort of be able to list out common attributes so that we can coherently define what's a community. Once you do that, then you may be able to, say, right, between the interests of a weaker community, like a sociologically weaker community, was the interest of a better off community, you have to favor the interest of the weaker community. So, for example, if doctors want the details of, again, anonymized, non-personal data of, say, an Adivasi community which had given its data for a particular kind of study, all right, you should be able to show that you will not cause them any harm in the first place, right? So you start with the very basic thing that giving this data to this, again, medical community may have a lot of use for it, but you cannot give them the data if there is any potential for harm. You have to first identify what is the potential for harm, but you have to be able to clearly identify. You're not just putting this data out there for anyone to use. Again, there are certain kinds of balances which need to be drawn, but you have to be very clear what is the community that you're talking about. Otherwise, this will not get you anywhere. It won't be possible for you to resolve. If you don't define that community well enough, you will not be able to resolve that.
And any decision that the NPDA takes would then be potentially subject to litigation?
Of course it will be. It will be, of course, subject to litigation, because as a governmental authority, people can approach the High Court against the decisions. They can go up against us. Whether or not the law provides for any review, there will be High Court will have judicial review. You can test it on the pedestal of fundamental rights. If it is a body, assuming that addresses everything, that if it is a body set up under law, you can review it by filing a case in the local High Court of appropriate jurisdiction and directing them to do this, not do this. Don't.
So Alok, just as a side question, if there are communities that are constitutionally defined, can the government create laws that define additional communities?
Yes, that's not so much of an issue. The government can create laws that define additional communities as well. That's not so much of a problem, so long as you don't contradict the purpose for which the Constitution has defined certain communities. So, for example, if the Constitution says this is the list of castes which belong to the scheduled caste category for the purposes of reservation, the government can't say some subset of these group of people will be given special benefits to the exclusion of others, right? This is a constitutionally determined category, right? You can't say I'll give a special benefit to certain people in this group and not the others. So you will have to say, if this caste falls within scheduled caste, I will have to adhere to this constitutional requirement. But there may be groups which are not defined under the Constitution, so you define them accordingly. But there's per se not a problem with that definition. But again, you have to keep in mind what is the purpose for which it was defined in the Constitution and what you're trying to do with this particular definition. So that question of what is a community also comes into the picture. And again, if you're looking at it from the perspective of data, if you try and use a general sociological category, it may be right, but it may completely mislead you when you're trying to regulate non-personal data.
Understood. I think Malvika has a comment to make or a question to ask. Malvika?
Oh, thanks for bringing me in, Nikhil. I thought you would just, I'm unable to access the Q&A box, so I sent my question to Nikhil. But I think I was just going back to this conversation we had right up front. To buttress Alok's point, I think Alok is trying to do a lot of mental gymnastics to make this connect to community rights under the Constitution to give it some kind of moorings in regulatory theory. My impression is, just coming from the philosophical data literature, I think the big point there is community members are unaware of their self-identity of as belonging to that community, right? So to your point, Alok, I don't know if I'm in a data set as a person who buys this kind of car.
Sure.
So therefore, even as a whatever sociological or computer science concept, it's pretty much meaningless or even a bit of a nonsense, I think, to say that such a community can have that level of self-awareness that they will then set up a Section 8 company to claim rights and do redress and so on and so forth. So yeah, I think the most tenuous link you could form is under the Constitution, but even that, I really don't see how it applies in a private law framework like this one.
Oh, no, I don't disagree at all. I was just sort of exploring some of the possibilities if we could go there. But yeah, no, my point wasn't necessarily to say that this is definitely how it can be done. And you're completely right. I hadn't yet gotten to the point about how would a community even form, as you rightly put, an entity to represent itself. Will every member of the community have a say in it, or a certain representative? I mean, there are huge agency problems in the middle there as well. I hadn't gotten to that as well, but you're perfectly right about that.
Thanks, Malvika. So, Alok, Alok and Benny, actually, I think we're running out of time. We might. So, yeah, Alok, while talking about the NPD framework, you sort of the understated purpose of the NPD's existence seems to be that some of the functions of the CCI have been given to it in terms of like enforcing good faith within the market. So what do you think about this interplay between the CCI and the NPD? Do you foresee any conflict between these two bodies?
Hugely. Because to me, I think the latest version of the report, if you see, I just spotted this paragraph while reading it. I think it is paragraph 7.10, sorry, 7.12.3 sort of says maybe harmonized. I'm afraid that's a gross oversimplification of the problem. We are currently seeing a massive fight between TRAI and Competition Commission of India over the regulation of mobile service providers. I think it's not as simple to say quote unquote harmonized. I think there needs to be clear lines drawn. And to me, anything which relates to competition or abuse of dominance should fall within the ambit of the Competition Commission of India. And especially if it is, and it need not necessarily be only post facto. It can also be a priori. Competition Commission of India does have rule-making powers, does have the power to issue guidelines to sort of say that this kind of conduct will not invite competition scrutiny, or this kind of conduct will invite competition scrutiny, and so on. So I think where the fear is that somebody sitting on a lot of data, and what fear, it's actually happening. Somebody sitting on a lot of data could potentially use that to shut out competitors entirely. I think the Competition Commission should be the one, because it is already empowered to do this. It has an array of regulatory tools to do all of this. It may do it well, it may do it badly. It may need a certain bit of capacity building in terms of knowing how to assess problems related to data and so on. That can be done. That's a fairly solvable problem. But we don't want to create a new problem where the boundaries of one authority, this NPDA, conflict with that of the CCI, and there is constant conflict as to where my jurisdiction ends and yours begin. I think that is an avoidable problem, and for that reason, you may just want to leave it to the Competition Commission of India to address this problem, build up their capacity if required. I mean, I've recently written a paper on this front along with my co-author Manjushri about saying that it's not just about saying Competition Commission should do something, but their capacity to be able to take on the likes of Google, Facebook, or Amazon should be buffed up. And not as in terms of legal powers, but in terms of knowledge, expertise, and so on.
Benny, what do you think about this conflict that Alok is also foreseeing?
think I have a question more than an answer again. And my question is that the task of the competition authority, is it only to kind of rule over abuse of dominance, or is it also to uphold and preserve competitiveness generally? And the question is to Alok, but also anybody else.
Sure. So it addresses both cartelization and abuse of dominance, but it exercising its legal powers comes into the picture only when it finds that there has been, or there's a possibility there is an abuse of dominance. But it can put in place certain guidelines and so on to say that such kinds of activities will not invite our scrutiny. Like, for example, it could say, in the context of data, even if you have 95% of share in the market for any particular digital product, if you're willing to share the data with competitors or anybody who asks for it on the payment of a fee, we will not think you're dominant, or we will not think you're abusing your dominance. But if you are somebody who very closely guards your data as a secret, as a trade secret, and then there are questions of competition and IP and all of those come into play as well. But if you're somebody who has sort of essentially prevented competition from entering your particular field using the data, then I think there is a question for the Competition Commission to take action against. So while its regulatory powers need not necessarily be linked to preserving competition, it can act only when it finds abuse of dominance. But I think it can set certain guidelines and standards in this regard.
Yeah, and I think the whole idea of asking this question was, in a sense, that this whole framework could have actually been subsumed by the Competition Commission in that sense.
Absolutely, absolutely. I completely agree.
So I think we're just expending precious regulatory capacity when one regulator doesn't have enough already. So, yeah.
I guess.
Just Benny, just something that we discussed earlier. You know, it's almost like I get the feeling that the NPD authority isn't geared up towards, like, when it comes to data, and data being a toxic asset and essentially becoming a privacy harm by itself when it's released out in the open, and that's possible with the NPD as well. There is a need for friction of sharing data, which is possibly what the PDP bill should also be doing. I'm just wondering whether the people who formulated this report do you think that they've given enough thought to creating friction in terms of sharing data, or is it basically going to be an open tap of sorts?
Nikhil, I think this goes back to my previous point of a principled reasoning being missing, right? Like, there are competing benefits and competing kind of harms from data sharing, and harms are mostly borne by citizens, consumers, communities, whatever you have to call them, and benefits are for small startups. And I think then there are derived benefits which the committee is very exuberant about, and those derived benefits are innovation and economic growth for citizens. The first order harms of citizens don't get as much salience, and therefore, to your lens of applying friction, I think that we need more friction. We need kind of, a decision making points where we say that no, this is not the type of situation where you get access rights, or certain data types are exempt, not just from government, not just like exempting government's kind of treatment of non-personal data, but saying that this data by itself is, even though anonymous, it is not in the community's best interest to kind of get this data out. We haven't even given this, I think, committee's report a thought from minority communities kind of lens. And I'm pretty sure that there, even what seems innocuous and non-personal is not as innocuous, and there are huge kind of red flags that can occur when we study this from that lens, and therefore friction is needed. What that friction looks like, I'm a little more optimistic than Alok is. I do feel that we can get to a certain framework where we can imagine or articulate some kinds of harms. And we say that if that is the kind of harm, then even if the data custodian is acting in the best interest, or is kind of following the duty of care relationship, even that is overridden and said that actually these kinds of cases, you cannot share data. And we don't need to look a lot further. We do know how non-personal data has been giving away very sensitive information, for instance, electoral choices that individuals made in the American election. Just, I mean, I don't know if you guys, obviously you guys must have heard about it, but there was some recent research which basically showed from the MIT that from publicly available data sets, you were able to predict people's political inclination with 99.8% accuracy. And then there was a lot of voter-based distinction that came on those people. So I do feel that there are certain databases that should definitely not be in the purview of this. And the constitution is the starting point, but some principle of harm, some notion of decisional autonomy should go into thinking and filtering out data sets that cannot be shared under
Right.
this.
So there's a set of exceptions that should be defined under which data would not be available.
Yes.
Okay. I'm just going to take a few questions that were again shared on chat earlier. Aparajita Bharti asks, can the NPDA realistically ensure that data businesses are sharing all the fields of metadata they collect? Realistically, anyone?
I honestly don't think so, because you'll have to first make that obligation under law that you have to share all this data. You'll have to give the MPDA the power to basically go in and see, are you sharing all this data? You're creating not just a regular with an enabling function, but an extremely strong enforcing function, because it's not like it's not like you're getting anything from the regulator for giving all your data. It's not the regulator's job to go and find out if you have disclosed all the data. It'll basically be like another tax department. Are you giving all your data to the government?
The report also doesn't envision penalties for not sharing.
No, it doesn't. And again, it doesn't come through from the design of the authority that it will have such teeth in terms of enforcing powers to be able to go and say, I'm not sure you're giving me all the data, make sure you do. So which is a problematic thing. I mean, okay, it may be good to do that in certain contexts. I'm not so sure it's necessarily needed for every single field of human endeavor.
Okay. Arpit's question was, do you feel that all the concerns on the IPR front have been addressed? The report mentions about trade secrets being subject to eminent domain requirement. I think it's more like sovereign access, but in terms of compensating data custodians, the report only allows reasonable charges for data processing, not data collection.
Benny, would you like to take that?
I'm actually sticking my neck out to say this, but I don't think that there are sufficient incentives that are imagined in the report for people to host such HVDs, to keep them encrypted, anonymized, and protected. I don't know, and that's just on the HVD side, but also on the data custodian side. Maybe there's something in there that I have missed in the 2 reads that I've had so far. But a lot of this just assumes that there is going to be a law and everybody is going to comply. And the costs of compliance are not really discussed in great detail. So I am not sure if they are going to be compensated enough.
Okay. Keshav Thakur asks about public good. He says that as we understand, besides the public good justification for policy and social economic benefits, high value data sets can also be utilized by startups and SMEs to create new business models. Does the new business also have to qualify the public good criteria?
So yeah, this is where, I mean, Nikhil, when we had that initial conversation, we have to disaggregate these two things. If it is a public good, sure, different governments should come up with their own frameworks at local levels to say, we would like to use this data for something and therefore give it to us or give it to this agency. If you're doing it for business, why not just pay for it? It should be ideally part of a free exchange. Sure, we'd want to give our startup sector some sort of a benefit and a boost, but at some level, it can't just be that you completely hand over data sets to your competitor just because we say you should. And this to me feels a little bit like the license, what Raj was it? License permit quota Raj, where you're basically saying, no, you don't determine the price. Government will determine the price at which you should get access to the data. To me, I don't think that is the approach at all that should be adopted. Even if we make a limited argument that data is a public good, it should be used. I think at best it should be left to each government, each entity to figure out how to do that. I don't think the same justification applies in any way for a free private exchange between two parties of rough, maybe there may be slight difference in bargaining strength, but you as a startup have to show why you need access to this data, and whether you'll be able to compensate them appropriately, and what is the benefit that you're bringing, that there is a proper, that you're not just simply picking up this data and giving it away tomorrow to my competitor, but something that you will be able to do to give more value to my users and your users. So I think that shouldn't. I don't think we should conflate the two justifications for this.
Okay, and Anonymous attendee is asking, the revised report states that the data sharing must respect intellectual property rights. However, India does not have statutory trade secrets protection. What mechanism does the report provide for businesses to protect data that is commercially sensitive or confidential? Either of you?
I didn't see anything to that effect, and please, anybody who knows better may correct me, but I did not see too much by way of how it will protect trade secrets, specifically trade secrets law, because it's not codified. It is something you have to show. Let's just understand one thing. It's not as if today you can file a police complaint and say trade secret was lost. You have to show it's your trade secret, that it is something. One of the reasons why trade secret is not protected under law is simply because there's no obligation to give it to an authority, right? It's something that is not, unlike copyright, it's necessarily put out in the public, or patent, for which you go to an authority and get a patent, or a design which you go to an authority, you show that this is my design, give me protection. Trade secret, you can do whatever you want, and as long as you show that this is mine and nobody else gets to have a look at it, it's protected under law. There's still a duty on you to show that it's a trade secret. So I think that's I at least did not see in this report how they will harmonize that aspect of it, but it is a complex and tricky question as to how we will address the trade secret part of it.
So I guess it needs to be addressed. I was going to ask Rahul Matan if he has a view on this.
I knew you'd do that. So look, trade secret is protected by trade secret. Essentially the protection is confidentiality, right? So the US has a trade secret law, but companies today protect their trade secrets through this principle of confidentiality. The biggest example is Coke. Someone knows that secret, no one else knows it. That person dies on a plane. You have better hope the other guy who knows the secret is not flying in the same plane with him. Otherwise, we will not have Coke anymore. And that's the way in which trade secret law has been protected for forever. So this report attempts to do nothing about that. In that that regime is a regime that exists. All that this report points out is that to the extent that there is some clarity that is required with regard to overlaps with proprietary ownership of data in the first place. The report makes it clear that that is not the intention. The intention is not to pick up proprietary information. That information, intellectual property, is protected under copyright law, patent law, and trade secret law. And those laws will continue to apply because it's not the intention of this report to even invade into that territory. So I don't think this law should, in fact, legislate on all of that, because we already have law. What we should be very clear about in this domain is not to accidentally impinge on something which is already well regulated by an existing well-established field of law. And I think that is the, as I said when I interjected earlier, that was the deft sidestepping that this report has done to clarify some of the questions that were asked in the context of the previous report.
Thanks, Rahul. So I think we're running out of time, but if it's okay, I'll just run through some of the questions before we close, everyone. SM asks about what is accidental misuse of data? How are we to hold companies liable or accountable if they accidentally misuse data? And what are the standards for defining this? Benny?
I do know that there are different standards of liability that basically are, So different levels of kind of accidents or different levels of malfunctions attract different levels of liability, which is to say that if a person has with intentions done something wrong, then that attracts a higher level of liability. But I think that in this case, if as far as I think, and I'm not a lawyer, but as far as I think, accidental misuse is not a defined term in the law, and therefore we'll have to just wait for definitions. It seems to be an easy carve out for anyone to say. Maybe, I mean, I think my first hunch is it's prone to misuse, because you could easily claim that this was accidental and probably hope for like a lower level of liability slash penalty. But I don't think this is defined in the law, and we'll just have to wait for details.
Okay.
I could be wrong because I'm not a lawyer, guys.
Alok, do you want to address that?
Nothing specific except that, again, I agree with Benny. At least as a concept, I'm not very clear what accidental misuse would really mean. I'm also not very, I don't know if it can be easily defined in some legal terms to even be able to figure out what the consequences are. I can understand accidental access, like you're looking for something and found this, but misuse means that there is an element of thought behind that use. It's not like you accidentally put in credentials and you found something. It's that there is some. It's not just a quick momentary thing, like within an accident or something like that. It feels like it is a much longer kind of event. I don't know how that can happen, quote unquote, accidentally. So I'm also not sure how how consequences can be provided for that.
Got it. So Kiran Gopinath, who I know used to run or currently runs an advertising data business, asks, how will anyone know if NPD has been de-anonymized and used?
It's whistleblower, I guess. That's the only way I can think of. A whistleblower in a company, or somebody does an investigation and finds out accidentally. Yeah, it's the same.
Siddharth asks, are there any existing forms or examples of societies or organizations that can or should take the role of being a data trustee?
I can't honestly think of any.
Okay. Just one sec. Can inferences made from the data set be completely excluded? Where do the panelists see the right to a lot of this information, where corporations are able to predict knowledge of public interest, like Google's inferential ability to predict flu outbreaks? Also, what about right to portability of these inferences from a personal data standpoint, since these inferences are having no or threadbare protection in PDP or even GDPR? Do inferences become a gray area?
I think we have to segregate the two. I think inferences involve a certain level of capacity to even draw those inferences from the data. So, and it might be different depending on the context. So I don't know if we should link the two necessarily together, saying that you should be able to give your inferences also from the data. I don't think that is what is envisaged.
Okay. I think, one sec. There seems to be no regulation on how data requesters use the data from the high-value data sets. End-use restrictions would seem an obvious solution. What are the other ways to govern this? Could this translate into compliance challenges for smaller businesses? Benny, do you want to take a stab at that?
Actually, I have been thinking about this, that there are no end user restrictions. So what I can do is I can get access to this data and then use it in whichever way I like, right? So that's potentially a scope for market arbitrage as well, where I have been granted access under the government regime, but I could sell it to someone who would not necessarily qualify for that access. So definitely end user rights are important. But again, I think where my imagination completely breaks down is enforcement of this entire regime. And I don't know how you can enforce end user rights. I mean, we do know there are some very expensive technologies out there through which you can make sure purpose limitation, etc. If not complied with, there's at least a traceability to it, that how you used your data is kind of visible. But you can't really think of a DLT based mechanism for almost every new entrant. So I don't really know how you would comply, but I do see the need for this, as I do see this as a huge gap, but I'm at a loss of how we can remedy it.
Thanks, Penny. I think we're bang out of time now. I'd like to thank you and Alok, and also accidental panelist Rahul Mathan for joining us. Thanks, everyone, for a fantastic discussion. I think we are getting more granular with the discussion on NPD with each subsequent version of the report. I hope that the committee and we've had Parminder and there's Sindhu and Rahul here as a part of this discussion, takes feedback into account when the final report is prepared. I'd like to thank all of our speakers for their inputs. We will have stories on this up on MediaNama next week. The live streams are up on YouTube, Twitter, and Facebook in case you'd like to revisit any part of this discussion. I'd like to thank Microsoft and Facebook for the support for this discussion, and especially thanks, Keshav, for your questions. I think they were fantastic, and hopefully you can join us for more discussions from here on. We would appreciate your feedback in terms of what we could have done to make this discussion more interactive. And if any of you would like to write for us on this particular subject, more than welcome. I would also say that the committee has a requirement that the submission that you send to them be kept confidential, or you ask for it to be kept confidential. In case you'd like to share a copy with us for publishing on MediaNama to make that information public, to make your views public, please feel free to send me a copy at nikhil@medianama.com with a line that says that you'd like me to make this information public at MediaNama. If you ask me, I think this information should be available publicly. That should be disclosed, just with all consultations. And it's quite disappointing to see this secrecy here, just as it was in case of the Sri Krishna Committee as well. I hope we see more public disclosures from government committees and government departments from here on, but it seems to be reducing, especially in the tech space. But thank you all for a great discussion. Really appreciate it. And looking forward to the next one. We are planning to do one on the 28th on data and AI. And the idea there is to essentially unpack the thinking around the need for data for both NPD, for AI, as well as the need for data from an economic growth perspective. We're looking at that as two sessions, essentially. One is going to look at data, AI, and utility, and the other is going to look at things from a privacy perspective, where we look at data, AI, and privacy. So I hope you can join us then as well. Thank you, everyone.
Thank you. Bye-bye.